Okay. Good evening, everybody. I'm calling to session the July 9th, 2024 Liquor Board hearing, and it's now in session. Mr. Praley, if you would, please.
All right. Thank you, Mr. Chairman. Good evening, everybody. Nice to see everybody here tonight. My name is Jimmy Praley. I serve as the board's counsel. Just a few brief announcements before we get going tonight. The commissioners before you are all part-time public servants. Each and every one of them have outside interests. So when they know that they have a conflict of interest, they'll recuse themselves. However, due to the number of cases that we hear at each meeting, due to the ability for members of the public to show up in support or opposition, it'd be impossible for the commissioners to know whether they have a conflict at the outset. So when your case is called, if you believe that a commissioner or several commissioners may have a conflict, you need to make that, you need to make the board aware of that at that time. Then we will discuss and make an appropriate ruling. Otherwise, we're going to proceed forward under the supposition that there are no conflicts. Secondly, this board's rules and regulations have dictated that counsel may rule on objections and the admissibility of evidence if counsel are present and objections are made. So if your case is opposed or if there are members of the public who are going to appear in opposition, and there are rulings that need to be made on the admissibility of evidence or a particular line of testimony, it may be the case that instead of the chairman turning to me advising the chairman, I will simply make a ruling on the evidence or the testimony, and then my ruling will be that of the board. That is all I have for tonight, so we will turn it over to our Chief Inspector, Mr. Ford, who can call the first case. Chief Inspector Ford, please.
Thank you, Mr. Prilley. Welcome, everybody. Our first case is Crofton Liquors, J and Harry LLC. Mr. Kim, would you like to waive the reading?
Mr. Kim, will you waive reading?
Yes.
Thank you.
Okay.
Thank you very much. Anybody wishing to testify for or against, please come forward, remain standing, and raise your right hands, please. Do you solemnly swear and affirm under the penalty of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth? Thank you very much. You may be seated. And we are going to start with my left. If, sir, you could state your name and address for the record.
Detective James Mountcastle, Anne Arundel County Police.
Detective Thomas Middleton, Anne Arundel County Police.
Detective Charles Cepeda, Anne Arundel County Police.
Good evening, members of the board. Bob Kim on behalf of the licensees.
Bipin Patel.
Your address, sir.
Give him your address.
My home address.
Yeah, your address.
1510 Augusta Way, Crofton, Maryland, 21114.
Harry Patel, 6810 Green Holloway, Highland, Maryland, 20777.
Okay, thank you.
Scott Montaigne, Liquor Board Inspector, and Arundel County Liquor Board.
Okay.
Thank you,
Inspector
everyone.
Montaigne, you can have a seat anywhere in the front row. Thank you.
All right, officers, if you could just provide us with a statement of facts, please, regarding this incident.
Good evening, everyone. On April 7th, 2024, approximately 10:30 hours, Detective Mountcastle, Detective Middleton, and myself were conducting Operation SAVE, which is conducting alcohol sales compliance checks of retail businesses. We directed a confidential source, 21 years of age, to enter the Crofton Liquors, which is located at 1641 Crane Highway, Crofton, Maryland, which is in Anne Arundel County, Maryland. We observed the confidential source enter the business. The confidential source went to the store and picked out a 12-pack of Coors beer from the front counter and took it to the front counter. The clerk did not ask the confidential source for identification, but asked him if he was 21 years of age. The CS replied yes. The confidential source was given official Anne Arundel County funds and was able to purchase the Coors beer from the clerk. Confidential source then exited the business immediately, turned over the alcoholic beverages to myself and the other detectives. We know through our training, knowledge, and experience that Coors beer is an alcoholic beverage. Myself, Detective Mountcastle, and Detective Middleton both entered the establishment, identified ourselves as law enforcement. That's okay. Yes,
To make sure.
that's okay.
All right, I apologize.
That's okay.
Go ahead.
So Detective Middleton, Detective Mountcastle, and myself then entered to the establishment, identified ourselves as police officers and law enforcement, and identified the clerk as Harry Patel, has a date of birth of April 28th, 2004. Mr. Patel advised that he has been working at the establishment for only 2 months and advised that he has had the alcohol awareness training. Detectives asked if Mr. Patel was on the manager's agreement, and he advised that no. Mr. Patel advised that the manager was due to come in the store at approximately 1,300 hours that day. Mr. Patel advised that the main manager is always there on days. A photograph was taken of Mr. Patel, and the Anne Arundel County liquor license was properly displayed. Photograph was also taken of the alcoholic beverages, the Coors Light beer, and was properly destroyed. Mr. Patel was cooperative. The store was not busy at the time, and a copy of this police report was forwarded to the Anne Arundel County Liquor Board. No further statements.
All right, thank you, Detective. Thank you, Detective. And I apologize for the interruption. That was my fault. I had the wrong case on top. So, Mr. Kim, this is your opportunity to question the detectives based on the statement of facts, if you have any.
Thank you, Mr. Burrow. Just a couple of questions. For information purposes, what was the date of birth of the confidential source?
I don't know, but I can give that to you if you want to look at it.
Just 1 second.
Upper right-hand corner.
The date of 2000,
Yeah.
December 16, 2003.
Yeah, that's a Maryland certified code of his driver's.
He would have been 20. Correct?
19.
This was April 2024. Okay. Right. Well, I think we were in 20. Okay. And you said Mr. Patel was cooperative, didn't cause any trouble?
No, Mr. Patel was cooperative.
Okay. Mr. Presley, the facts really are not in dispute. That's all I have of the detective.
Okay, I'm going to see if the commissioners have any questions of the detective based on the statement of facts. Mr. Chairman.
Thank you. I do, and I'm just going to ask some questions that you may have already mentioned in the report, Detective, but I just want for clarity to make sure. So you asked the clerk if he was on the management agreement?
Yes, yes.
Okay, and he said no, correct?
Yeah, that's correct.
Okay. And there was no manager or a licensee on the premises at that time?
No, sir, not at that time.
Okay, very good. And knowing you looked at the ID of the clerk? Do you have it, and the date of birth was, I believe?
April 28, 2004 is correct. That's not in dispute, Mr. Chairman. I think April 28, 2004 was the date of birth.
Correct.
Okay.
There's a picture of his ID.
That's not in dispute.
Okay, so what was his age at that time?
He would have, just before April 28, I guess he was 19. 19, you would have been 20 in 2 weeks.
Okay, and that's the clerk's age?
Yes, sir.
And he was the only one in the store selling?
Correct.
Okay, again, just for clarity. All right, okay, no further questions at this time.
Commissioner Snoops, any questions?
No questions.
Commissioner Duffy?
No question.
All right, Mr. Kim, we'll turn it over to you. Go right ahead with your case.
Mr. Presley, I did send to Mr. Aronson copies of alcohol awareness training certificates for Mr. Jay Patel, Mr. Nilesh Patel, and Mr. Harry Patel. I believe I do have another copy.
We have copies. Those will be accepted.
I thought I did, but I did not send a copy of the letter from the board to the Crofton Liquor dated April 11, 2024, listing 2 managers for Crofton Liquors, Michael Schmidt and Nilesh Patel. Here's a copy of it. I thought I made a wrong assumption that since a letter came from the board may have it, but.
Also.
We do have them, Mr. Kim. Thank you.
So if I can ask for admission of those documents into evidence. Again, Mr. Chairman, Mr. Brady, as I stated, the facts are not in dispute. I've had a number of discussions with Mr. Harry Patel, who was on premises that day, and Mr. Bipin Patel, the licensee. If I may be permitted, there are 4 charges in this case. The first 2 charges are for sale to a minor. Again, one is violation of Section 4.01 of the rules and regulations of Anne Arundel County. The second one is Section 6.6-304 of the Alcoholic Beverages and Cannabis Article of the Annotated Code of Maryland. Again, I'm not exactly sure why there are generally 2 charges for a sale to a minor case. I mean, I do appear before other boards, and I don't see other boards do that. But again, I would submit to you that if there is a violation, there should be one violation for sale to a minor, either under the rules and regulations or article, alcoholic beverage and cannabis article. As to the third violation, Section 3.01, ownership and operation. Because the facts were not in dispute, I was trying to come up with ways to turn it off. To bring to the attention of the board sections of the alleged violation. Again, I don't think factually there's a dispute as to violation of Section 4.01, sale to a minor. Section 3.01C, however, talks about ownership and operation. It states, 3.01C, all licensees shall file a management agreement for any and all managers at their establishment on forms provided by the board. But we did that. I've actually thought that you needed to have a manager on premises at all times. Well, the section doesn't actually state that. It says you need a management agreement filed with the board, which we have done. So I would ask the board to invite the board's attention to Section 3.01C, which I think is pretty clear on its face, that you need a management agreement filed with the board, which there is compliance. The fourth violation is 3.14C, which states, in its captioned as employees. Subsection C says, no person under age of 21 may act as a packaged goods clerk. A person 16 years of age and older may work as a stock clerk, stocking alcoholic beverages. If you look at, I would invite the board's attention to Alcoholic Beverages and Cannabis Article 4-504. And I think I may have made another copy of this. Board's indulgence. And 4.4-504 of the Alcoholic Beverages Article, and for the board's information, and Mr. Pirelli knows this, it's the section of the Alcoholic Beverage and Cannabis Article that applies to all the counties. Section B1 of 4-504 states, except as provided in paragraph 2 of this subsection, an individual between the ages of 18 and 21 years may be employed in the sale of beer and light wine. Subsection 2 says, an individual under the age of 21 may not be employed by a holder of a Class D beer, wine, and liquor license in the sale of alcoholic beverages. Well, this is a Class A license. It seems to say in that alcoholic beverages article that if you're between ages of 18 and 21, and again, I think he was 19, he can sell beer and wine. Now, I understand the county section 3.14 is different than what's stated in the alcoholic beverages article, but I would submit to you under the statutory interpretation, the board has the right to enact regulations to, I guess, enforce alcoholic beverages article, but it can't be different. The rules and regulations can't be different than what's in the statutory provisions. So I would submit to you that even though it does go against section 3.14 of the rules and regulations, because statutorily it is permitted, I think that rule should not be enforced in this case. Actually, I think the rule should be changed to comply with the rule, article, alcoholic beverages and cannabis article of Maryland Code. So, Mr. Chairman, Mr. Berg, again, the facts are not in dispute. Those are our arguments or presentation in terms of the alleged violations in this case. If I can summarize, the first two violations, I think, really is one violation. That's really not in dispute. Parts 3 and 4, I think, based upon the interpretation of the statute and the rule, I would submit to you that this licensee is not in violation of those two, the last two counts or last two allegations.
Okay, thank you, Mr. Kim. I want to thank everybody for their indulgence for the time. Just wanted to make sure that I understood everything the way it was presented and the way we understand it. I do have some questions.
Yes, sir.
Correct me if I'm wrong in what I'm about to say, but my records show that there's been violations for sale to minors. One was on February 6th of 2021. Another one was on June 19th of 2021. And that means that if found guilty, this would be their third offense in less than 3 years for sale to minors. You can check and confer with them, but I'm pretty sure I'm correct in what our records indicate.
Well, I guess this would be second within 3 years, Mr. Chairman. Because I know there was one in June of 2021. That would be within 3 years. I think the one prior to that was, if that was in February, I think that's a little more than 3 years. I don't want to be technical, but
No, but you're right. 3 years, I was kind of rounding it off, but nevertheless, this would be the third one in less than 5 years, which is what normally when we look, we try not to go too far back. Otherwise, we have places that have been in business 52 years, and I'm sure we could, come up with But nevertheless, this will be, if found guilty, the third violation for sale to minors within 2.5 years or whatever you want to call it. I also, and I want to make sure you do agree with that, Mr. Patel, correct? That this is, okay.
That's not in dispute, Mr.
Okay, no further questions at this point.
Commissioner Snoops, do you have any questions?
No questions.
Commissioner Duffy?
No question.
All right, Mr. Kim, anything you want to add?
Mr. Chairman, members of the board, again, we're not here to make excuses. And again, as the detective stated, Mr. Patel, even though he knew that this was an issue, was cooperative. He answered all the questions that he needed to answer. There may be some extenuating circumstances as to why he was there, but that's, I didn't even bring that up because it really is not relevant for the purposes of this proceeding. The violation happened. We are taking steps to make sure that, again, listen, I know you've heard it before, but we're taking steps to make sure that this doesn't happen again. And we ask that the board take that into consideration, the retraining of the employees. And again, Mr. Patel has been instructed that he cannot be there by himself, and he cannot be, I mean, he generally is the guy that works as a stock person, but it was a situation that required him to be there by himself, and again, that's not an excuse. And he should have carded, he should have done what he was supposed to do, but we would ask that the board take that into consideration in the imposition of a fine or penalty.
Okay, thank you, Mr. Kim. Okay. Again, I just want to point out the severity of the fact that this is the third time in
Yes, sir.
2+ years or 3+ years. And because of that, I do think the severity of this particular violation is so noted. What I'd like to do, or what I'm going to do, is I'm going to make a motion. And Mr. Kim, what I'm going to do is make a motion that we do merge the county rules and regulation and the state charge. I'm going to make a motion that we find you guilty on that. And because it's the third offense, fine you $1,500, $1,500. On the ownership and operation in reference to the management agreement,
Yes, sir.
I'm going to go ahead and make a motion that we dismiss that charge. And then on the last one, in reference to employees, I have a real problem with someone under the age of 21 being in a Class A establishment, whether at that time they were selling beer, wine, that alcohol, they could have just as easily have grabbed, a bottle of whiskey or something else. I do think that Mr. Patel, Harry, I believe, should not have been in that store, especially by himself.
No question.
And because of that, I'm going to take and find you guilty of that. And I'm going to make a motion that we, because of the severity of that plus the third offense, I'm going to go ahead and make a motion that we suspend the license for a 3-day period to include a Friday, Saturday, and a Sunday. Okay, that's in the form of a motion. I'm looking for a second.
I second the motion.
Okay, thank you. I have a second. All those in favor?
Aye.
Aye.
Mr. Chairman, will we know the dates, or would the board, your office let us know?
Yes, we will. We will. We'll try not to pick a holiday weekend if that helps you any at all. But please take note that the reason I gave this suspension is a short period of time, 3 violations of sales to minor. We're not going to tolerate it. I mean, you really need to step up and make sure you have the proper people in place and that you check the IDs and so forth. Okay?
Yeah.
Thank you.
For the board's information, what makes this really more confusing to attorneys, in Prince George's County, Montgomery County, you have to be only 18 to sell any kind of alcohol. So it makes it a little confusing for some of my clients. He should have known that, but that's, it's for information purposes, it just really makes it confusing. It would be great if all the counties of the state had the same rule and regulation regarding the age of the employee.
Yeah.
So,
I understand that, and I understand your point, and the point was well made. Okay, so we have a total of $1,500 in fines and a 3-day suspension. Okay, thank you very much. You're dismissed.
Thank you all.
thank you very much for your time.
Thank you, gentlemen.
The officers have another case, correct? Yeah.
Our next case is Ridge Wine and Spirits, RK Stores LLC, Rishi Kapoor, managing member, John Gorman, member, Janisha Kane, clerk, Evelina Carrasco, manager, Detective Middleton, number 1061, Detective Mountcastle, number 1155, Detective Cepeda, number 1239, Inspector George Matthews. This is a Class A beer, wine, liquor, beer, wine tasting and Sunday license located at 2659A Annapolis Road, Hanover, Maryland 21076. It is not restricted. There are 2 violations. The first violation is for a violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 4, Section 4.01A, minors, regarding Anne Arundel County Police Report number 24-713174 by Detective Middleton, number 1061, and Detective Mountcastle, number 1155, and Detective Cepeda, number 1239, incident dated April 14th, 2024. Second violation is for violation of alcoholic beverages and cannabis article, Annotated Code of Maryland, Title 6, Section 6-304, selling or providing alcoholic beverages to individuals under the age of 21 years, regarding Anne Arundel County Police Report number 24-713174 by Detective Middleton, number 1061, Detective Mountcastle, number 1155, and Detective Cepeda, number 1239, incident dated April 14th, 2024. Anyone wishing to testify for or against, please approach, raise your right hands, remain standing. Do you solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may be seated. This time we'll start with Inspector Matthews to my left.
George Matthews, Anne Arundel County Liquor Board.
Detective Mountcastle, Anne Arundel County Police.
Detective Thomas Middleton, Anne Arundel County Police.
Detective Charles Cepeda, Anne Arundel County Police.
Rishi Kapoor, address is 1010 Deep Skies Drive, Laurel, Maryland 20723.
Avelina Carrasco, address is 2412 Marriott Drive, apartment 410, Jessup, Maryland 20794.
Johnny Chicane, 1951 Palmetto Drive, Hanover, Maryland 21076.
Thank you very much.
All right. Detectives, go ahead, please.
Excuse me. I apologize, Detective. Is a Mr. Gorman, John Gorman, here? Mr. Aronson, Mr. Gorman was summoned, correct?
Yes.
Let him know that the summons was signed on behalf of him. He has been notified.
Okay, thank you. We have a case right now where Mr. Gorman did not show, and he received a summons, a legal summons, which was signed by someone other than him, but a letter was then sent to him at his present and known address, and also an email. And because of that, I'm going to go ahead and postpone this case. And you need to bring Mr. Gorman in here. And I'm also going to ask that the charge of cooperation be added to these charges for his failure to show up here. Okay, so first of all, do you understand what I'm saying? Because Mr. Gorman, who was summoned, legally summoned, failed to show up when he was supposed to, and it's his obligation. And he could have sent us a notification saying he wasn't available or whatever the case, and may have been excused. He didn't do that. And because of that, we're going to postpone this case to the first available hearing. And I hate to do it to the officers, they're busy enough, but I'm sure they understand. And then hopefully, when they're resummons, he will show. And the charge of cooperation for the failure to respond here tonight will be added to the charges. Okay? You understand? All right, I'm going to go ahead and postpone the case. This case is now postponed. You'll be notified of the next date of the hearing. Okay? Thank you, and I apologize. You need to talk to Mr. Gorman.
Our next case is Southgate Liquors. Southgate Liquors, Inc.
Thank you, Mr. Bittner.
Thank you, Mr. Bittner. Anyone wishing to testify for or against, please approach and remain standing. Inspector Barnes. Please raise your right hands. I'm sorry, sir. Please remain standing. Thank you. Do you solemnly swear and affirm under the penalty of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you very much. You may be seated. And Inspector Barnes, we'll start with you. Your name and address for the
Inspector
record.
Earl Barnes, Anne Arundel County Liquor Board. Thank you.
Agent Morgan, Maryland Alcohol, Tobacco, and Cannabis.
Thank you.
Good evening, Mr. Chairman, members of the board. Richard Bittner, VITTNER, on behalf of the licensee, Mr. Aswan Savali.
This is Ashwin Savalia. Residence is 8138 Bell Tower Crossing, Maryland 21122 from Southgate Liquors Corporation.
Thank you, sir.
All right. Inspector Barnes, do you have a statement of facts that you'd like to provide?
If I may,
Sure.
Mr. Chairman, members of the board, preliminarily, I don't believe Inspector Barnes is a part of this alleged violation. This is a state controller violation, record keeping. And I've had an opportunity to review the report and speak with Agent Morgan. And if the board please, we have a proposal that perhaps could resolve this matter. My client's had the license since 1995 with no violations of this type, any type, like record keeping, invoices. He had one violation in 2005, not him personally, but an employee for sales to minors. So in light of that, in light of the liquor, 6 bottles of Grey Goose, 750 milliliters, where invoices could not be accounted for that have been forfeited with a value of $259, the state is satisfied if this matter is continued without a date, they'll be back in for another check, a routine check. And the state would be satisfied, if the board is satisfied, if at that next routine check, he's in compliance like he has been in compliance every other routine check since 1995, that this matter would be closed without a disposition. So it would be, if the board please, in the nature of a step, an indefinite postponement. So it's hanging over his head. He suffered a forfeiture. He's here. He gets it. He's always got it. But we're asking, and the inspector, I believe, is in agreement given his long history of compliance, and he was cooperative on that day and has always been since 1995.
Agent Morgan, is that your understanding?
Yes, as long as the product is forfeited, that's all that we need.
Okay, and my understanding, Mr. Bittner, is the product has been forfeited.
And we're not seeking any return of that, and place that on the record, correct, sir?
Yes.
All right, let me talk with the chairman really quickly.
Thank you, Mr. Fraley. Mr. Bittner, I'm going to make a ruling or make a motion on a ruling in a second, but before I do, I want to correct something. You said there's only been one previous violation. And that was I think you were talking about May 26, 2005, in which they paid a $250 fine for sale of a minor.
Mr. Chairman, I believe that that's the only one that I had a 2025.
2005.
Year 2000, there was on May 12th, there was another sale of minor violation, which he received a reprimand, which was the earlier of the two. So the first time he received a reprimand, the second time he received a nominal fine.
It was before 5 years, 2005. That means maybe 2000 maybe.
I'm sorry, I
My
can't.
client confirms that you are correct, that there was an
Maybe
incident in 2000 and in
2000 and 2005.
Okay, I just
I
want
did
to
not
correct that. No, I want to correct it for the record. I want to make sure.
No, absolutely,
And-
I did not.
The last one was 2005.
I'm still looking.
That's okay.
Never had, if I may, it's never had a invoice record keeping violation.
Understood. And he's not here for sale or non-compliance as far as sale to a minor, so, but it's just the point you brought up that he only had the one violation. Agent, so you're okay. I assume there's going to be another inspection within what kind of time frame?
I don't have a set time, but I like to keep it more of a surprise, I guess you'd say.
Okay.
Instead of giving them an exact date.
You understood what he was saying there, Mr. Sabalia?
Yes, yes.
Right? A surprise is a surprise. That means anytime. Okay, I'm going to go ahead and make a motion that we agree to a step under those circumstances because the agent, I think, is being very kind and in agreement. And of course, it involves the confiscation of the alcohol, which is already in the state's possession. And then I'm going to ask that we postpone, I'm going to say indefinitely, but that actually means that once the agent goes out and does a reinspection, if you would notify us in writing that you've done that,
Okay.
and that they either are or are not in compliance.
Yep.
And at that time, we'll make a final decision on this. All right, now I'm going to put that in the form of a motion. I'm going to ask for a second.
I second the motion.
Thank you, Commissioner. I have a second. All those in favor?
Aye.
Aye. Okay, Mr. Bittner.
Thank
you're
you all very
dismissed.
much. Thank you,
Thank you,
agent.
gentlemen.
Thank you.
Please take this warning as a real serious warning because I don't know where that alcohol came from, but it should never reappear. Any alcohol that's not purchased legally through a distributor and the proper records kept. Have a good day.
Thank you. Thank you very much.
You're welcome.
Okay, our next case is Village Liquors, Shri Nilkanth Inc., Ishvarbai Patel, Second Vice President, Satish Patel, Vice President, Karit Patel, President, Secretary, Treasurer.
Mr. Hurdle, will you waive the reading?
Yes, absolutely.
Thank you very much. Anybody wishing to testify for or against, please approach and remain standing. And Mr. Chairman, I do not believe that Inspector Alsup was a part of this investigation.
That's fine. Inspector, you can have a seat. If we need you, we will ask you to stand.
Thank you, Inspector Alsup. I'm sorry, please remain standing. Raise your right hand and repeat after me. Do you solemnly swear and affirm under the penalty of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. You may be seated. Agent Hawk, if you could begin by stating your name and address, please, for the record.
Agent Joel Hawk, Maryland Alcohol, Tobacco, and Cannabis Commission.
Patel, 23613 Triganic Drive, Clarksburg.
Ishwarbai Patel, 103 West Ordnance Road, Glen Bundy.
Satish Patel, 6808 Arundel Lane, Laurel, Maryland, 20707.
And Counselor?
Abraham Hurdle on behalf of the licensees.
Thank you very much.
We would, I guess, would have an admission in part and would dispute, I guess, the violation aspect of it, though.
Okay.
If I may.
So what we'll do is we'll have Agent Hawk provide a statement of facts. We'll let you question and we'll go through the whole process here.
Thank you.
Okay. Thank you. Agent?
Yes, sir. On Thursday, March 20th, 2024, at approximately 9:50 a.m., I responded to Village Liquors located at 720 Church Street, Baltimore, Maryland, 21225, for the purpose of a routine inspection of the business. Upon entering the location, I spoke with the owner, Mr. Patel. I identified myself as an agent with the Alcohol, Tobacco, and Cannabis Commission. I observed the trader's license on the wall to be valid and properly licensed for the products they had for sale in the store. I conducted a systematic inspection of cigarettes and other tobacco products displayed in the store. Mr. Patel produced invoices for the cigarettes, and on inspection, they all appeared to be valid Maryland tax stamps. Their liquor license, 556 Type A, issued by Anne Arundel County Liquor Board, was displayed on the wall and valid. I conducted a systematic inspection of alcohol on the premise and found a box of Ciroc, 750 milliliter, with the shipping label cut off the box. I found another box containing Fireball Whiskey 100 milliliter with the shipping label to a different store, Soda Pop Shop. I asked Mr. Patel for the invoice for the Ciroc and why he had a box of Fireball labeled for a different store. Mr. Patel was unable to give a reason why the box of Fireball was in the store, nor produce an invoice for the Ciroc. I seized both boxes of liquor. Village Liquors was in violation of ABC 6-311, purchase or keeping alcohol beverages from other than a wholesaler, and ABC 1-408, records violation. Mr. Patel signed the confiscation receipt, and the liquor was seized to the evidence room at Alcohol, Tobacco, and Cannabis.
All right, thank you, Agent. Mr. Hurdle, questions?
Sir, was any of that liquor returned to the establishment?
The Ciroc was, yes, sir.
Because it was found to be purchased by them, correct?
They found an invoice 2 years earlier that had Ciroc on it, but I could not match the label to the invoice.
But
we still turned it over
to them. And the other box of alcohol, what kind of alcohol was it?
It was Fireball whiskey.
And that was in a particular size, correct?
100 milliliter.
You were able to see an invoice that showed that they had purchased significant quantities of Fireball whiskey, correct?
It was not given any invoices. I asked him to produce it for the Ciroc. The box was labeled for Soda Pop Shop. He could hand me 100 invoices for that liquor, but that box did not belong to that store.
Sure, I understand, but how far is Soda Pop Shop away from this location? Would it possibly be
a couple miles?
Is it the next place on the breakthrough beverage delivery route?
I would not have that information.
Is it possible?
I would not have that information.
But you're familiar with the stores in the area, correct?
Yes, I am.
But Soda Pop's store is not far, correct?
Like I said, a couple miles.
And have you seen this invoice that shows they purchased on the same day they received a delivery of 74 cases of alcohol, including of that 35 that were Fireball whiskey?
No, I did not.
Would you like to take a look at it?
No, sir.
Is it possible that the delivery driver, when dropping off 74 cases and 35 cases of Fireball, may have accidentally dropped off an extra case?
The violation is that the box belonging to the Fireball was supposed to be a Soda Pop Shop. It's the owner's responsibility to conduct his business and take proper stock of his invoices and his product.
The violation is for them buying it from some other retailer. Restrictions on purchases and sale by a retail dealer, correct?
Yes, sir.
So the accusation is that they bought it somewhere at retail, correct?
Yes, sir.
But you've got no proof of that, and in fact, their invoice indicates that they ordered a huge quantity of this. And I'm just asking, is it possible that the delivery driver who, I mean no offense to delivery drivers, maybe have been in a rush that day to drop off 74 cases, of which many, almost half, were Fireball, may have accidentally dropped off an extra case?
I'm not a delivery guy. I never have been a delivery guy. I can't say it's possible or not.
Was this the only case of Fireball that they had at the store?
Labeled Soda Pop, yes, sir.
I'm sorry, sir, my question was this the only case of Fireball they had at the store?
To my recollection, no.
So they had many cases of Fireball at the location?
I wasn't concerned about those. I was concerned about the one that was listed for another shop.
Sir, I apologize. My understanding is this violation, which occurs, it shouldn't, occurs from stores who run out of something on say a Tuesday or a Wednesday and can't wait till next Tuesday or Wednesday to get their wholesale delivery. So they run down to a different store, buy some quantity, and now they have saleable merchandise. In this case, they had huge quantities of this exact product, including the exact size item, which would negate any real reason for them to have gone down the street to the next delivery stop and bought a case with the label on it from a competitor.
I'm sorry, is that a question?
Does it make more sense that it was an accident as opposed to them just overstocking something from a competitor?
I'm an agent. It was in violation. I seized the property. It could have happened. Sure, anything could happen. But it was on his premise, and it was the wrong store. You talk about the law is set for, the law set for people that own 2 or 3 liquor stores can't buy in bulk and ship it out to the other stores and sell it cheaper also.
Do they own 2 or 3 stores?
I have no idea, sir.
Did you not look into that as part of your?
No, sir.
In your experience, this isn't your first time citing this violation of an establishment, correct?
No, that's my first time. I did 25 years in Baltimore Police Department, and I've been on the liquor board.
I object. Come on, what are we doing? I'm asking him a serious question, and he's being flippant.
No, he's not. I don't think so. I think
He asked my experience.
I asked him this was his first time citing this violation.
And I said, yes, sir.
You said yes.
Have you had any other experiences with this sort of violation?
Doing liquor board?
Have you cited anyone for
No, sir.
retail purchase like this in the past?
No, sir.
I have no further questions.
Okay. Mr. Chairman, questions?
When you went in there, agent, and you pointed this out to the licensee, what was his reaction to that? His immediate reaction? What did he tell you at that time when you pointed out?
Yes, sir. He had no answer for either boxes. I asked him to produce the invoice for the Ciroc that was returned because the label was specifically cut out. It wasn't ripped off or anything. It was specifically removed to hide the location where it was supposed to be. The soda pop box, there's no answer for it. I mean, could it be an accident? Absolutely. But as the owner of the store, as an agent of Maryland, I have to seize that property because it does not belong in that store.
I understand. I have a question for Mr. Patel.
Let's just go on this first, and then we'll let.
Oh, okay. No, I
I just want
apologize.
to keep the record
I'm
clear.
getting a little anxious here on the questioning, and I apologize. When you left the store, you took both cases with you?
Yes, sir.
Correct? And you returned one of them?
Yeah, the Ciroc, yes, sir.
Okay, because they found an invoice,
Yes, sir.
but they did not find it on the day you were out there,
No, sir.
correct? How long between the 2 times, from the time you went there and the time they responded with it?
I want to say 2 to 3 weeks at most.
Okay, thank you. No further questions at this time.
Commissioner Snoops, any questions?
No questions.
Commissioner Duffy, any questions?
No questions.
All right, Mr. Hurdle, we'll turn it over to you. You can
First and
present your-
foremost, we would admit that the Fireball whiskey was not theirs. There's no question that it was or wasn't. We have no dispute. There's no reason for them to have gone to another retailer to have purchased that. I spoke to my clients, and I can certainly ask them to testify that their understanding is the delivery route that Breakthrough runs, that the next delivery location is the soda pop stop. They ordered 74 cases that day. I have an invoice in my hand from 12/14/23, and that date shows 74 cases, of which 35 alone were Fireball, of which I believe 2 were of the 100 milliliter size. So they had a huge inventory of this product on the single day that they got this delivery late last year, and they would have been selling through it for months and months. They would have had no reason to go to the next adjacent store to buy a case of this alcohol when they were stocked. And they had bought a huge quantity. We're happy to submit this, and I'll happily have them testify to this if they'd like. Sir, can we state your name again for the record?
Excuse me, Mr. Hurdle. Do we have a copy of that invoice?
I'm not sure.
Was that submitted? If not,
We'd be happy to have it submitted. We'll just, we get a copy of it back.
That's okay.
For various reasons.
It's in here.
Yeah, I looked, I couldn't
I
find
think
it.
it's attached to the report, but I can't be.
My client had sent in a letter at some point explaining all of this too.
Right.
It's right there.
Oh, it's on a letter for, okay. Yeah, I was looking through the invoices themselves.
Page 2 and 3 of the invoices. Seem to show the fire.
Just to speed up the review, we have a lot of invoices here. Can you bring those up? Can we see those really quickly? I think
Absolutely.
the chairman would like to take a look.
Yeah.
At those.
We do need them back.
Yeah, absolutely.
We'll give them back.
Yeah, absolutely.
Otherwise, you'd be in violation of record keeping, I believe.
Okay, we do have a copy of the Ciroc invoice, which was from 2022.
Thank you. Do you want to look at that one? See the other one? The other liquor.
Absolutely. It's Ciroc. Coming up.
Give it back to him. Yes, please. Yeah.
That's just that one, and then we have the copy of the Ciroc.
Okay, you can take this to him also. Thank you, Mr. Hurdle.
Thank you. Sir, could you please state your name for the record real quick?
What do you mean?
Could you please state your name for the record?
Is like in my name?
Yes, your name.
Satish Patel.
When you guys placed this order,
Yeah.
the reason you bought huge quantities was
Right,
for the
it's
volume discount.
Around like 50K steel something.
So you bought a lot of it.
Yeah.
How much of that's still in the store?
It's probably like 3 months something after the we're gonna order the every time like that.
So you ordered huge quantities every 3 or 4 months?
Yep. Right.
I have no further questions at this time. I would like to sum up when given the chance.
Sure. Do you have any questions, Mr. Chairman?
Who received this shipment from the distributor, which included this particular box? Which, Mr. Patel or?
Actually, when the delivery come here, that time is they have the so many cases, so we have to have the not checking every kind boxes for they have the store name, the village liquor, yeah, somebody different store name. So it's huge quantity, so it's not have the time to check it out there.
Yeah. I've been in many liquor stores when they receive distributors' shipments, and I know they're pretty adamant about checking boxes because they're paying for it. Once that driver walks out, then they're going to end up
it's
being charged.
That boxes come from the in the that delivery guy make mistakes should be like that. I know that, yeah.
Okay. No further questions at this time.
Commissioner Snoops, do you have any questions? No. Commissioner Duffy, any questions? No questions. All right, Mr. Hurdle, go right ahead.
Thank you. First, I want to say I appreciate Inspector Hawk taking the alcohol. I think that box of Fireball certainly doesn't belong to them. We have no contention that it's ours We're glad it's gone. We admit that it shouldn't have been there. I don't know how it got there. It certainly, in my review of the paperwork, and my client sent a letter into the liquor board, I guess in April, summarizing much of what they believe to be the same argument we're making today, which is a huge quantity came in, an extra case got dropped off, that was the one that was found, and we lay no claim to it. I think that's an easy one to explain because the simplest explanation is likely the truth, and that is just that an extra case got delivered and we're glad it's gone. This rock presents a bigger concern for me because I don't know why the label was cut off. We do have an invoice that says they purchased something in 2022. It's 2 years prior. I have significant concerns as to why that was set up that way, but I think the fireball, again, it makes sense that that would be an error that could have occurred. Despite the hard questioning, again, I do appreciate the job that the comptroller has, and I do appreciate his candid responses today.
Okay. Thank you, Mr. Hurdle.
Okay.
Mr. Chairman.
Bear with me 1 second.
No, they sell it. They sell it? The comptroller sells liquor.
Really?
Mm-hmm. You put it on pallet.
Gentlemen, your mics are hot.
Okay, Mr. Hurdle, the hurdle's over. Or huddle. I meant to say the huddle's over. I'm going to make a motion. You pointed out a couple of things, Mr. Hurdle, in reference to the label being cut off and also in reference to what I feel is a failure on their part to check the invoice when it was delivered to make sure everything is there. And because of that, what I'm going to do is make a motion that we find them guilty of record keeping, but I'm going to find them not guilty in the other case as far as purchasing from another distributor because of the ambiguity involved in that. And I'm going to make a motion that a fine, and by the way, you have a pretty extensive record with this board, and not necessarily with this type of incident, but I think it needs to be noted that, you're too well known to this board, so please be careful in the future. But I'm going to make a motion that we find you not guilty on the first charge of purchasing from not purchasing properly to a distributor, find you guilty of the second, and find you $500 for that. That's a form of a motion. I'm looking for a second. Okay. Look, with that being done, I'm looking for a vote. I have a second. All in favor?
Aye.
And aye. Okay, Mr. Hurdle, thank you. Gentlemen, please be careful of the agent. Thank you very much.
Thank you. Thank you, gentlemen. Our next case is La Fogata. Thank you, Mr. Lyman. Anyone wishing to testify for or against, please approach the table. Remain standing and please remain standing and raise your right hands. Please remain standing, everyone. Raise your right hands. Thank you.
Do you solemnly declare and affirm under the penalty of perjury the testimony you gave is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Your name and address for the record, please.
My name is Ricardo Bello.
Corporal David Zorman, Anne Arundel County Police.
Corporal Christopher Wilson, Anne Arundel County Police, ID number 2028.
Corporal Daniel Hayes, ID 2169, Anne Arundel County Police Department, Southern District.
Corporal DeWitt, Anne Arundel County Police, ID 2285.
And Corporal Smith, Anne Arundel County Police, ID 1852.
Inspector Pelletier, Anne Arundel County Liquor Board.
Ricardo Bello Serrano.
I'm sorry, sir, your address for the record, please, Mr. Serrano.
421 Merriman Road, Annapolis, Maryland.
Thank you.
Ricardo Jr. Veo Alvarado, 8137 Harold Court, apartment 3A, 21061.
Milton Ardonis, 6000 Busy-Wood, Greenville, Maryland.
Thank you.
And good evening, I'm Brian Lyman, Lyman, counsel on behalf of the licensees, and I would note for the record that licensee Sean Hicks requested an absence tonight. He's traveling overseas, and I believe that was granted.
That's correct. Thank you, Mr. Lyman. Mr. Ford, who is going to be providing a statement of facts tonight? Is that going to be you, sir?
I'm going to start.
Okay.
Before you do, if I may, I believe you officers, if you're willing, you're welcome to sit in the first row. You don't have to stand the entire time. Corporal Smith, you're going to be staying where you're at.
Yeah, I'll be the lead officer.
Okay. I'm sorry, Chief. Go
That's
right
okay.
ahead.
So before I start, prior to my statement of facts, I'd like to make a motion that my report and all attached exhibits, which have also been provided to the licensee and licensee's counsel, be moved into evidence and become a part of the record.
And I would object based on hearsay.
Okay, that'll be overruled. That'll be admitted. Thank you, Mr. Ford.
Thank you. So this report is dated 2/28/24 by Chief Inspector Ford regarding La Fogata located at 3029 Solomons Island Road, Edgewater, Maryland 21037. On February 26, 2024, I received an email from Corporal Edward Smith, number 1852 of the Anne Arundel County Police Southern District, in connection with multiple incidents during the weekend of February 24th to 25th, 2024, at the above referenced licensed establishment. See the attached email. Via email, I asked Corporal Smith for a copy of the report as well as any additional information, and was provided with both the police report and a CAD report highlighting calls to the Anne Arundel County Police over the last 12 months. Both documents are attached here too. I subsequently spoke on the phone with Corporal Smith for further information and context. Such information and context to which he has agreed to testify, including assault and physical altercation between several establishment employees. Those facts presented to me in my conversation with Corporal Smith led me to reach out to licensee Sean Hicks for additional information. I contacted Mr. Hicks, and Mr. Hicks agreed to speak with the manager of the establishment regarding the incidents and get back to me. When he had spoken with the manager, Mr. Milton Ordonez, Mr. Hicks did call me back. During that conversation, no new mitigating facts were presented to me, based on his conversation with Mr. Ordonez. As a result, and based on the facts presented to me by Corporal Smith, I decided to issue a citation to the licensee for violations connected to public welfare and illegal conduct. End of report.
All right, thank you, Mr. Ford. Mr. Lyman, questions?
Mr. Ford, in your report, you mentioned that no mitigating facts were mentioned to you. Can you give the board an example of what mitigating facts might have made you reconsider filing charges in this case?
That perhaps there was no fight, something that was an alternative fact, something that disputed the facts that were presented to me by Corporal Smith. Okay. Anything that made me feel like something didn't happen that Corporal Smith told me.
Right. Corporal Smith indicated to you that he didn't witness the fight, correct?
Correct.
Okay, so he wasn't there and he never saw the individuals fighting, correct?
He did on video.
Okay, so he reviewed a video.
Correct.
But he wasn't there in person to testify about what led to the fight, what the disagreement was about, if there's any context, how many patrons were there, any of those things, correct?
I believe that's correct.
Okay. And you don't know anything about this situation except for what Corporal Smith has reported to you, is that correct?
Correct.
All right. Do the violations that are being charged tonight involve any events that occurred other than on February 25th?
No.
2024? So those are the only issues that we're here for the board to consider, correct?
Again, as you and I have discussed in the past, Mr. Lyman, context is important. History is important. But to answer your question directly, that's correct.
All right, so there's no other alleged behavior that my clients are expected to respond to the board about tonight except the allegation that a fight did or did not occur on February 25th, 2024 at the establishment, correct?
I think that there is a history here that warrants review.
Okay, and that history is not actually in your report, is it?
It's located in the attachment to my report, in the CAD report.
So what attachment is the history that we should be considering in this case that involves facts outside of what happened on February 25th?
I'm sorry, could you repeat that?
What is in your report that indicates facts that you want the board to consider that are outside of the incident that occurred on February 25th?
I have attached a CAD report provided to me by Corporal Smith, which involves many incidents over the last several months, year at least.
Is this it?
Yes.
That's what you're referring to?
I believe that I can't see it, but that looks like what I'm referring to, yes.
It looks like
And I can read down it if you'd like me to.
It's a 3.5-page document. Yeah, if you'd show that to Inspector Ford.
Yes, this looks like the same document.
All right, do you have that document in front of you by any chance?
I do.
Okay. I'd like to ask you a few questions about it. Have you counted the number of no report dispositions on this report?
I counted all of these at one point. I saw enough red flags here to know that this was a situation that, again, warranted further review by the board.
Okay, great. You've got the whole report in front of you, correct?
Correct.
Okay. Can you identify the first red flag situation that caused you to write the violation that we're here for tonight?
Well, just off the top of my head, there was a murder there about 2 years ago. We've had several, I've been informed of several police calls over the past few years. We've had neighbors complaining.
Okay, so the murder that you're referring to is not actually on this report, is it?
It's not.
Okay, so you're now considering things that are even outside what you said was the limit of what caused you to bring these charges.
That's correct.
Is that correct?
That is correct.
Okay, so we're not really here to talk about what may or may not have happened on February 25th. We're here to talk about the character of these licensees, okay? Is that right?
I think we're using what happened in my report as an inciting incident to review the history and context of this location, which has a sordid past.
Right, but Mr. Ford, you would agree with me that your job is to cite violations of the board's rules that you have witness testimony to support at a hearing, correct?
Generally, yes.
Okay, and yet you've acknowledged that you've cited these licensees not just for what is alleged to have happened on February 25th, correct?
No.
Oh, so again, we're back to my first question, which is we're just here to try to understand what happened on February 25th, 2024 with an alleged fight, correct?
Correct.
Okay. And so all of the other information in your report, you're not trying to prove any of that tonight, are you?
I think it's context for the board to consider how they may adjudicate this.
Okay. But it doesn't really have to do with whether or not there was a fight and whether there might have been a breach of the rules and regulations that night, correct?
No, of course there is. I mean, that's exactly why we're here, to find out what happened that night.
Okay.
Yeah.
And based on your personal knowledge, what happened that night that breached the board's rules and regulations?
I would defer to Corporal Smith's report.
Okay, so you don't have any personal knowledge or testimony that you can give about what occurred on February 25th, correct?
I don't, but when an officer goes in on a save operation, I'm not there, but they write their reports and they come in, and the board looks at that,
Right,
and they
and-
take the officers at their word.
That's right, and the board has to hear from the officers, not from you writing a report, correct?
Correct.
Okay, no further questions.
Okay. Do you have any questions, Mr. Chairman?
No questions at this time for the chief.
Commissioner Snoops, any questions at this time?
No.
Commissioner Duffy?
No question for the chief.
All right. Okay, who's going to be presenting the case for the officers tonight?
Corporal Smith.
Great. Corporal Smith, go right ahead and provide us with a statement of that, if you wouldn't mind.
I wrote a testimony, I'm just gonna read it to you. Good evening, I'm Corporal Edward J. Smith, ID 1852 of the Anne Arundel County Police Department. I've been in the department for 13 years. In the past 10 years, I've been in Southern District Midnight Platoon. The reason myself and some of my partners are here tonight is because we are concerned about the establishment located at 3029 Solomon's Island Road, Edgewater, Maryland 21037. It is currently named La Fogata and was previously named Los Chaparitos. In 2022, when the business was named Los Chaparitos, we had reports of a stabbing within the business.
Overruled. We're going to allow him to present a statement of facts, and then you can cross him on it.
And I personally responded to a shooting which resulted in a homicide at the above location. We've also responded to multiple calls of intoxicated persons who were stumbling in the area or even passed out on the sidewalk in front of the establishment. A few months after the homicide, in December of 2022, the business was renamed La Fogata. We noticed after the homicide, the business had quieted down and we were getting many calls for service. We weren't getting that many calls for service. This has since ended. On the weekend of February 24th, 2024, my partners and I responded to 4 calls for service, one on Friday the 23rd into the 24th, where an intoxicated subject was refused entry, but his friends entered and stayed while he was sitting in his truck, in their truck. This wasn't like a big issue for us. It was on the 24th at approximately 1:21 hours. I, along with my partners, responded to a fight with a large crowd outside. While arriving on scene, the group dispersed and the victim did not want our assistance. We left the location and 10 minutes later we responded for another fight. This time the fight was in between employees. 2 female employees started physically fighting behind the bar. Another employee attempted to break up the fight when a 4th employee comes from behind and starts attacking the employee who was trying to break up the initial fight. The employees in the initial fight stop fighting while the other 2 continue to fight. During the fight, one employee bites the other's right index finger, causing deep lacerations. Medical attention was recommended but ultimately refused. It should be noted the entire incident was reviewed on closed-circuit TV within the restaurant and can be viewed through my body-worn camera footage. A report was taken and neither party wanted to press charges at this time. At approximately 02:20 hours the same morning, my partners responded back to the establishment for a call for a loud noise in the parking lot. It appeared that after everyone left the bar and closed, the party continued in the parking lot. My partners had dispersed the crowd and got them to leave. It should be noted that this establishment backs up to a residential neighborhood, and these residents call about the noise when it gets too loud. From my observation, it appears that La Fogata hires a DJ on Friday and Saturday nights. In conclusion, it should be noted that between May 9th, 2022 through February 25th, 2024, there have been 25 calls for service originating from this establishment. These calls range from noise complaints, intoxicated subjects, fights, assaults, unknown disturbances, trespassers, hit-and-run accidents, stolen vehicles, and the shooting. I should also bring to your attention that we have caution notes in our CAD system for this establishment to always send 3 or more officers for officer safety. In my 13 years as a police officer, this is the only time I've ever concerned about the activities at an establishment that I have gone to the liquor board for assistance. My goal today is to prevent another shooting or stabbing at this establishment, and I believe if something is not done, it will only be a matter of time before the next incident happens. Thank you.
All right, thank you. Mr. Lyman, question?
Thank you. Corporal Smith, you said 25 calls, but I'm sorry, I missed the period over which the 25 calls.
Between May 9th, 2022 and February 25th, 2024.
Okay, and have you kept up records for assistance calls since February 2024?
No.
Okay, and you didn't check that before appearing tonight?
No, I did not.
Okay. Have you been on duty, on your night duty over this period and assigned to this jurisdiction?
Yes.
Okay. Have you appeared at La Fogata since February 24th, 2024?
I have not, no.
Okay. So you personally haven't received any additional calls or had any reason to be at La Fogata?
I have not.
Okay. And did you observe any fighting in person at La Fogata on February 24th and 25th?
No.
Okay, so you individually didn't witness any assaults or batteries?
Just what I saw from the closed circuit TV that the manager and the security guard showed me.
Do you know who called the police for incidents that evening at La Fogata?
I do not know.
Okay. And were any charges brought against any individuals as a result of activity that happened on the 24th to 25th of 2024?
No, because it was an assault that didn't occur in our presence.
Okay, and so there's a problem with proving in court, for example, that an assault occurred, correct?
Well, I have video of the assault.
I mean, but that's why you didn't bring charges, correct?
Because I didn't see it.
You didn't see it, and so you couldn't testify personally that you witnessed an assault, correct?
No.
So that's incorrect?
Can you say that again?
You didn't see the assault personally.
Yes.
And therefore, you couldn't testify of your own personal knowledge that an assault occurred at La Fogata on that evening, correct?
I mean, I could have applied for charges against.
Okay, well, tell me why you didn't.
Because they didn't seem like the victim and the suspect did not seem like they were going to even cooperate with us at that point.
Okay, and what's the problem, practically speaking, with the victim and the suspect not cooperating with charges being sworn out?
It wouldn't have gone anywhere in court.
Okay. And I think this is the CAD sheet that you provided to Chief Inspector Ford?
I did.
You recognize that?
Yes.
Okay. And can you just answer, like, how is it that this record is made and maintained? Do you know?
Through our dispatch system.
Okay. And is it the dispatcher and they enter something in the computer and it gets put
When a
into
call
this
comes
list?
when a call comes in, the call taker puts the call in, and then the dispatcher dispatches the call to us.
Okay. I see a lot of number 32 periodic checks on this report. Can you describe what that is?
That's when officers, we drive by or drive through the parking lot to check the business.
All
To
right.
make sure everything's okay.
But that doesn't mean that a call came in, correct?
Does not, no, that's usually self-generated.
All right. The other items on this list, if the board is inclined to look at them, are resulting from calls that were made by the public or somebody to a dispatcher of the police, right?
Yes, any other calls besides the periodic checks?
Okay, I see one on here that there's a recovered stolen vehicle on 1/17/2023.
Yes.
Do you have any personal knowledge of what happened?
I
in that
recovered that
incident?
vehicle.
What's that?
That car was, I was the officer in that case.
Okay, and what happened in the case?
The vehicle was reported stolen earlier, and when I drove through doing a periodic check, I located the vehicle back in the parking lot.
So you discovered that a stolen vehicle
It was
had-
reported stolen, and then I found it in that parking lot.
All right. And then was it recovered?
Yes.
All right.
Or the owner was notified and told where it was.
Okay. A traffic stop wouldn't have been generated by a call, correct? If that's shown on this list?
No, it could have been right outside of the business.
Okay. Do you know when these licensees obtained their license from the liquor board?
I do not know.
Okay. Do you know if they're the same licensees as were operating Los Chaparritos?
I do not know that.
Okay. Was the staff, when you were on scene the evening of February 24th, cooperative?
So, yeah, the manager and the security guard were cooperative, yes.
Okay. And
I mean, they showed me the video. So.
Right. It looks to me like there was another noise complaint later that evening that no report was written for on the 25th.
Yes, that was when we just had the.
Okay.
them
Did you?
dispersed from the. I did not respond to that.
That wasn't you. That was one of your associates.
Yes, I was busy on another call.
Okay. And you, I think in your report mentioned that there were 2 fights that night, or 2 reported fights. Is that correct?
There was a fight before that. Before the employees started fighting. Yes.
All right. And that was reported with a request for EMTs, correct?
They might have been requested, but then just canceled once we got there, when no one said they wanted medical.
Okay. So I'm curious because I think you indicated that the finger laceration occurred on the indoor fight.
Yes.
But the EMS were requested previously according to this CAD report. Do you see that?
So this first one was, this one's between the employees. Or no, yeah, I'm not sure why that says, it said EMS needed, but when we got there, no one,
right.
Everyone left.
So the first call here is listed 2:25, that's actually the next morning, right? Sunday morning.
Yeah.
at 1:10 and 38 seconds, and this is the one that said EMS are requested, correct?
Yes, but then when we got there, no one would, the suspects were gone and the victim didn't want anything done.
Okay. And then you didn't request EMTs for the fight between the employees at 1:21?
We suggested that they get medical attention, but they didn't, she refused.
Okay. I don't have any further questions for Corporal Smith. Thank you.
Mr. Chairman, questions for Corporal Smith?
I do. I'm a little familiar with the CAD program that you have. And I went through and I highlighted those things other than the periodic checks that Mr. Lyman's talking about, and ones that I didn't think were relevant or pertinent. And I'm coming up with all different degrees from the fight, noise complaints, disorderlies, trespassing, assault. What's a 1057 and a 1050? There's two of them.
That's a hit and run accident. It's a 1057, and the 1050 is just a regular accident.
Oh, okay. All right, very good. Well, that's one I couldn't hide.
And I don't know if you should, if this makes any difference or anything, but that shooting that night came out as unknown disturbance, so it's not.
It wasn't what it was.
It wasn't on that sheet as a.
Understood.
As a shooting.
Thank you. Noise complaint, suspicious subject, disorderly conduct, recovered stolen vehicle, which was explained, another noise complaint. And I believe the question was asked to you if there was anything since February of 2024 as far as a CAD update or anything like that.
There might have been one other call, but I wasn't working or familiar with it at all. So.
Okay, thank you. I know all 5 of the officers were sworn in. Can I just ask for a hands? Do all 5 of you officers work this sector or post? If so, would you just, okay, all 5 do. All right. Thank you. I guess in reference to, I think I've heard mentioned several times about a body cam video, and it's not entered anywhere that I can see.
I have it pulled up on my computer.
Well, I'm not sure. Mr. Lyman, would you like to see it or no?
I haven't been privy to able to review it previously, but if it's going to be considered by the board, I'd certainly like to see it.
And this was in reference to a fight, I believe you said?
Yes, this is the fight between the employees in the bar. It's just it's my body camera footage viewing their
monitor.
Their monitor, yes.
I see. I understand. Unless the other commissioners would like to see it, I think I understand the principle behind it, and knowing that it's there, we don't necessarily have to see it though. Thank you. At some point, it appeared that things quieted down, if I can use that expression.
Yeah.
Do you know when that was or about when that was?
It's about after, well, when Los Chaparrillos changed its name after the homicide, it quieted down a lot, and then after the chief inspector's investigation, it quieted down. I think after the last postponement, after there were some stipulations or some things put on their liquor license that they can't do, it's been reasonably quiet there.
Yeah, there was an understanding, I believe. But, okay. I have no further questions at this time.
Commissioner Duffy, any questions?
No questions.
Commissioner Snoops?
No questions.
All right. Mr. Lyman, we'll turn it over to you.
Thank you. I do have the 2 employees who are involved in the altercation here. They're in the rear. I don't think the board necessarily needs to hear from them. I will proffer to the board that I did interview them right before this hearing, and they explained to me that largely what Corporal Smith was explaining was correct, that they were attempting to break up a scuffle that had occurred between other employees behind the bar who we were unable to obtain their presence tonight. And that's what they would testify to the board. And my suggestion is that the board has seen a situation here where the licensees have been making an effort to try to change the reputation of an establishment. Nobody wants to say that what happened at Los Chaparritos was acceptable, but also it really shouldn't be that much of the context that the board considers tonight. The board should consider the job of the peace officers in responding to and doing their jobs and resolving these issues at an establishment when the proprietors needed help. We had a situation where the bouncer, the main security at the bar, was involved in taking some unruly patrons out of the bar into the parking lot and asking them to disperse, which is the call 10 minutes before that the officers arrived for, and I'm sure the officers' presence at the site helped with that. Then there was the disagreement inside the bar between the service staff. This is all occurring pretty late at night, close to closing time, and I understand the nature of the dispute was over competition for customers or something to that effect. I don't have more details to present to the board about that necessarily, but the wait staff, were unruly between them. That is not disturbing the public, okay? That is a situation where management needed to deal with the employees, has dealt with the employees. None of these 4 employees are currently employed at La Fogata. And they are, I don't know if they're sorry or not. I think that they acknowledge that they made a mistake. I think that the last 2, the young ladies who are here tonight, are actually friends. And in the heat of the moment, in swirling around and defending yourself from maybe being attacked in a situation, the fight continued, or the scuffle continued, for a little longer than it should have. And I believe that's what, if you watch the body cam footage and if it's legible and you could see Corporal Smith, I think that's what you'll see is the windup of this scuffle between these employees and them realizing and coming to their senses, as it were. Their fight and flight reflexes had been triggered, and they were in fight reflex. They're in a situation where the management, you should look closely at what they should try to do to avoid something like this. In fact, these 2 employees who got caught, basically, on the surveillance footage weren't the original issue. They were the employees who were trying to break up the fight. Maybe we have a situation where there's some more training required. I have a copy of a proposed security plan for La Fogata that I'd like to hand up and have the board consider. That can be Licensees Exhibit 1.
It'll be admitted.
That plan is what they anticipate putting into effect when they get any business back. And that's the next part of my presentation, which is the board is here to try to accommodate the public and make sure that the public is receiving appropriate accommodation from its licensees and from establishments that are licensed to serve alcohol. La Fogata's sales report I have here in the months following and during the period where they have consented to no entertainment. Even though it's a privilege that's allowed under their license, they have agreed to no entertainment as an olive branch, if you will, to try to acknowledge and understand that this is an important issue before the board, and they acknowledge and understand that they need to have a security plan in place if they are able to have entertainment going forward in the future. The entertainment that I'm happy to come back and detail it at a different hearing, which may be appropriate, versus getting into what their plans are for supplying entertainment. The security plan is front and center in that. It includes lighting and cameras throughout the establishment. You saw that they were willing to share the footage with the police officers when they arrived. And they are cognizant that they need to have appropriate security to support the entertainment and the crowd that they hope to obtain. But let me get back to the sales report. La Fogata's gross sales for March 11th through 18th, that's 1 week, was $20,700.
That's 1 week. March 18th through 25th, $19,000. March 25th through April 1st, $20,000. April 1st through April 8th, $21,000. April 8th through April 15th is when we began with the no entertainment, $17,700. April 15th through 22nd, $17,185. April 22nd to April 29th, $14,871. April 29th through May 6th, $12,129. May 6th through May 13th, $10,968. May 13th through May 20th, $10,700. May 20th through 27th, $9,539. May 27th through June 3rd, $7,360. June 3rd through June 10th, $4,800. Mr. Chairman, Commissioners, La Fogata is not going to survive unless they're able to turn their fortunes around and entice customers back to their restaurant to serve the community, to provide responsible live entertainment, and to supply meals and drinks to the community. I lay that out there because those are the real hard economic facts here. And this is a situation where you have a restaurant location that has a bad reputation, that everybody knows is a bad reputation, that we've talked about here tonight, which I frankly think is a little unfair that we look back to when it was a prior establishment and had a different name and different management. And I think it's important for the board to consider its dual purposes, both enforcing the alcoholic beverage law as well as making sure that establishments are there to serve a community. And La Fogata serves a Latino and a Central American community that are not completely served in other establishments, frankly. They offer menu items, they offer hours of service in their kitchen that are not matched by other locales. If you go to dinner in Annapolis, they have one seating for dinner. A lot of these folks who are patrons are looking to unwind, they're looking to have fun with their friends, and they work hard, blue-collar jobs where they are looking for a meal later in the evening. They're looking to go in and obtain kitchen service and karaoke, some kind of entertainment, and on a weekend night. And that's the role that La Fogata would like to fill. That's the role that the licensees that are here with me tonight, and certainly Mr. Hicks understands this. He's a sworn police officer who's a licensee before this board. He understands the security issues and concerns. But fundamentally, we have a situation where you really haven't heard eyewitness testimony that there was illegal conduct that happened. We had allegations that were made in the police report. Charges weren't sworn out. We didn't go to court. There isn't a trial other than what we're having here tonight, based on hearsay evidence from Chief Inspector Ford, based on Corporal Smith's testimony about what the management of the restaurant diligently supplied to him when he arrived. And so we have a situation where we're here defending two charges, illegal conduct and public welfare. And it could be that this is a series of unfortunate events where we have the security personnel distracted and a fight breaks out between the staff. But my clients understand this, and they've paid a giant financial price already in the lost sales and had to cut staff back. And, there's jobs in the community that aren't being serviced because they have not been operating at the capacity that they're capable of operating. And we understand that there needs to be a balance, and we understand that the board and the commissioners are interested in striking that appropriate balance. What I would respectfully suggest is that the board consider a not guilty on the illegal conduct, because you haven't heard eyewitness testimony that there was illegal contact. You heard anecdotal evidence that there were facts that occurred that were insufficient for the police officers to swear out charges, and none of the participants, the victims, the complainants, anybody decided that they wanted to swear out charges. So we have a situation where now we have the public welfare. And it seems to me that just calling the police should not be the standard that this board holds the licensees to and for a public welfare violation. The police are specifically employed to help with the public welfare. And I understand Corporal Smith's complaint, and I understand why he thought it was important to talk to Inspector Ford, so that we could have a situation where the licensees would be answerable and understand their obligations. And I've worked for several weeks getting ready for tonight to explain to them their obligations. And they understand both the financial reality and the reality that, you know, our prior run-in over the dancing violation was, I think, much less serious than the allegations that are made here tonight. And they understand the seriousness of them. But I would say that the board needs to articulate an appropriate standard so that all the licensees can understand, not just these licensees, but all the licensees understand what's a violation, what's section 4.16 actually mean. Do we have to have proven illegal conduct by a criminal standard? Not under the law. However, it would be great if the board would announce what standard it is using when it makes its decisions. And that would really help my clients and my licensees who are here with me understand exactly how to train their staff and that there would be a bright line standard. So if the board is going to cite them for illegal conduct because they called the police and the police wrote a police report and then passed that along to the chief inspector, I think that that's a negative reinforcement loop. And I don't think the board should encourage licensees to hide the issues that they may be having at their establishments and not calling the police, because that's what escalates things. We have a situation where this management team is in place, they want to make changes, they want to be responsive, but they also want to be able to use the public services that are available to them from the police, from the EMS, when it's appropriate to use them. And that's what I would submit today is what happened here. That's what was appropriate for them to do, was to call the police because it's 1 o'clock in the morning, they're having trouble dispersing one fight, and another disagreement breaks out inside the establishment. I'd be happy to let my clients say anything if they'd like to say anything, licensees if they'd like to communicate to the board. I just want the board to have the right context and to realize that they do believe that this is an important issue that they have to deal with. But by the same token, the board's charging offenses here, frankly, were less than clear. It was very difficult to prepare for the case because we don't know what the illegal conduct is that's been alleged. So fundamentally, that's what the issue is. Are we defending the entire reputation of the establishment? Are we looking at all the CAD reports for however many calls came in? Or are we looking at one incident on one evening where, frankly, the licensee should have called the police, they did that, and now they're in trouble with liquor board for doing that. So, would you like to say anything to the chairman of the commissioners?
No.
And, you know, Mr. Hicks, I think, is sort of the usual ambassador to the board. And it was unfortunate, but he was traveling at this hearing date. So we thank the board for excusing him from the hearing. But I don't have anything else to offer. We would ask the board to carefully consider both the nature of the charges, announce the standard that it's using, and you know, consider an appropriate fine or any other penalty it might impose.
Okay, thank you, Mr. Lyman. Okay, it's a couple things that I'd like to try to clear up. One thing you mentioned was the disturbance, altercation, whatever, between the employees was not disturbing the peace. But I think you realize, even though you can't disturb the peace of those police officers, that if it draws attention to anybody other than the participants, that it in fact is disturbing the peace of those people. And there were other people in that restaurant. Is that correct?
I wasn't there. Were there other folks there? Mr. Ordonez was there.
Was there?
Oh, one. The manager was here. Could you come up and answer the chairman's question?
What was the question again?
Who else besides the two employees were inside? Yeah,
Please raise your right hand. Do you solemnly swear and affirm under the penalty of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth? Thank you, and could you please state your name and address for the record? Step up to the microphone. And that microphone needs to be turned on. Thank you.
So my name is Juan Vasquez. My address is 5601 Exeter Street, Georgetown, Maryland. And there was like maybe 3 or 5 customers the most at the bar at the night when that issue happens. And I don't know if you have any other questions.
Do you know, or perhaps one of the licensees can answer this, do you know what the ratio of alcohol versus food is?
We are selling about 50-50.
50-50 about?
Yes, we sell a lot of food. We bring a lot of authentic dishes from Central America, which is mentioned and nobody has it around here, like blow, mussels, stuff like that, and we usually eat on my country.
Okay. All right. Well, thank you, Mr. Vasquez.
Well,
Appreciate that. Haven't had a chance to review your security suggestions in detail. I guess I have a question for Mr. Serrano. We've met before. We've had meetings in the liquor board office in reference to your establishment, trying to help you grow. And when we've talked about things that you could do to make it a safe or a family restaurant. Now, I assume that these may incorporate some of those suggestions, but I think the most important thing that comes to mind is the fact that you're a restaurant. Your license is a Class H license as a restaurant.
Yeah.
Your principal should be food. You should be selling more food than alcohol. And the estimate Mr. Vasquez gave us is really kind of hard to tell, but I guess I'm concerned about the fact that when you opened up as a restaurant and you were talking about serving food for those people who like the Hispanic taste, and you were very proud of your menu and so forth. And the fact that it is a Class H, your entertainment, which you obtained at a later date, appears to be, in my opinion, appears to be part of the problem. And when I say the entertainment, I'm talking about the music and the dancing. And since you have agreed to cease during the last few months, things have gotten pretty quiet according to the officers. And I think that's an important thing for this board to take into consideration. I know I am. If we don't, in my opinion, I don't want to take your license from you. I want you to have your license, and I want you to have your liquor license as well as your, but I'm not so sure that entertainment fits that venue in that particular location, in that neighborhood. And I think that's part of the problem.
I understand. Well, we are trying to do the best we can, all the time. Like the restaurant is under a new manager, so they are working really hard on that kind of problems that he was on the restaurant before.
Okay, I'm gonna make a motion. I'm going to make a motion that we remove the entertainment from your license for a period of 1 year. Okay? And because you're a restaurant, and I understand that your gross and your nets have decreased since the entertainment has been removed, even though it was temporary. Hopefully you can get that venue back up and strong again using your food, the special foods that I'm hearing Mr. Vasquez and other staff members talk about. But I think using the entertainment to boost that at that particular location within that community is not the best thing. So I'm going to make a motion that we remove the entertainment from your license. You still have Sunday and you still have everything else. I would be willing to entertain a year from now if you want to come back in and perhaps request it at that time. We'd be willing to do that. So the motion is that we remove your entertainment from your license. I'm looking for a second.
I second the motion.
Okay, I have a second. All those in favor? Aye.
Aye.
Okay, that's our ruling. Lots of luck to you, Mr. Serrano. Okay, this case is dismissed.
Next case.
Thank you, officers. Thank you all.
Our next case is Magathy Inn, PCF Inc. Mr. Bittner, are you going to save my voice?
I don't believe on this one I can.
Understood, understood. Yep.
Excuse me. I apologize. I'm going to request a 10-minute break. It's in about mid-session, so we're going to recess for 10 minutes, Mr. Bittner, Mr. Page, and then we'll convene.
And folks, there is water in the hallway. It's a limited amount. You must drink it in the hallway. You can't bring it in. Sorry, you didn't see this. See if we can get out of here by 11. Just kidding. Just kidding. Just kidding. Just kidding, Earl. Seven-two Royals. Also starting somebody. Okay, thanks everybody. Settle back down. Our next case, I'm sorry, Mr. Chairman, are you all set?
All right, this session, the Anne Arundel County Liquor Board for July 9th session is back in session. Chief, I'm sorry for the interruption, needed the break.
Thank you, Mr. Chairman. Okay, our next case is Magathy Inn, which is PCF Inc. Paul Page, Vice President, Harry C. Page, President, Chief Inspector Jim Ford, Inspector Ace Chenoweth. There's one, Class D beer, wine, liquor, dancing and Sunday license with outdoor service, located at 546 Center Street, Pasadena, Maryland, 21122. One violation of the Board of License Commissioners for Anne Arundel County regarding violation number 1277 dated February 29th, 2024 by Inspector Ace Chenoweth and supplement report by Chief Inspector Jim Ford dated March 4th, 2024. Anybody wishing to testify for or against, please come forward and stand.
Do you solemnly declare and affirm the announcing perjury, the testimony about to give the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You can state your name and address for the record, please.
Jim Ford, Chief Inspector, Anne Arundel County Liquor Board.
Inspector Lacey Ace Chenoweth from the Anne Arundel County Liquor Board.
And Mr. Chairman, members of the board, my name is Richard Bittner. I represent the licensee. Boards previously waived Harry Page. I have let's say panache. That's how I view my client. A lot of panache.
Come on, Paul, we know better.
And we thank you for excusing Harry.
I'm sorry, Mr. Bittner, could Mr. Page state his name and address for the record?
It's Paul William Pace, 546 Center Street, Pasadena, Maryland.
Thank you.
All right, Mr. Bittner, before you get started, I note that you provided two motions to dismiss in this matter, one based on the doctrine of res judicata The next is a motion to dismiss for failure to allege a violation. So if you want to be heard on those preliminarily, we'll let you make some argument.
Thank you, and I would further incorporate in the motion to dismiss the docket entry. The agenda today does not reflect any statute that's been violation. It cites to a violation number 1277, doesn't cite to any chapter or section that's purported to have been violated. And that dovetails into one of our arguments, most respectfully, Mr. Chair, members of the board, that there's no notice, a citation charging an offense of other based on a restriction that purports to prohibit complaints. That doesn't charge a cognizable violation under the code or your regulations. And hand in glove with that, most respectfully, you've adjudicated these matters. This purported violation was tendered, was lodged on February the 29th for other complaints, restrictions of complaints received. As the board well knows, March the 28th, the requisite number of residents filed a protest for the license renewal, alleging the exact same, apparently, from what I can discern from this violation, the conduct that was complained of in that protest renewal. The protest renewal contained the same parties, the same participants, the same evidence, the same complaints, apparently, that are embodied in this February 29th allegation and supplement from March the 4th. There's nothing new or different that the board heard from what the board heard when March the 28th. The board subsequent heard on April the 6th. The protest was filed on March the 28th. On April the 16th, board well recalls the hearing that was held here. Again, same issues, same questions, same litigants, same parties, same witnesses. The board held a comprehensive hearing, and at the conclusion of that hearing, after reflecting, issued a well-reasoned opinion on May the 10th, where you found unanimously, as a matter of fact, there'll be very little negative impact on the welfare of the community with the renewal of the license, implicitly denying those complaints, finding those complaints to not have merit. You went on, members of the board, to opine in that opinion further that your inspectors had been out to the establishment 13 separate times since 2022, including the time period complained of by the protestants and purportedly alleged in the February 29th violation, and that the inspectors, quoting your order of May the 10th, not one time did the inspectors find any violations with respect to sound that warranted the issuance of a violation. So, Mr. Chairman, members of the board, you've ruled on this, you've decided on this. There are no protestants, no witnesses here today to offer any evidence regarding these violations. The allegations are simply that. They're hearsay by Inspector Ford. Inspector Ford clearly was trying to resolve the matter. He was trying to reach a harmony between these litigiously paranoid protesting neighbors. That is an impossibility. You saw the demeanor of the Todds. You heard their just incredible, unbelievable stories about how they were disturbed by minor noises and minor inconvenience that occur in a public life, particularly when you move into a home next to a well-established, well-regarded, previously non-violative of any rules of this board. So, Mr. Chairman, members of the board, you've adjudicated this, you've resolved it, and I'd ask that this matter be closed, dismissed.
You want to? No, that's fine. Thank you, Mr. Bittner. And after reviewing everything, I'm going to go ahead and deny the motions on those in both cases, and then we'll move on and listen to the case. But before I do, I'd like to get an idea of, is there anybody out there who is here in favor or in support of the Magothy Inn? And if so, please raise your hand.
All right, let the record reflect we have 2 individuals here in support.
All right, is there anybody out there who is in opposition or opposed to the Magothy Inn for any reason? We have
We have
one.
one individual in the back.
Okay. We have one all the way in the back. Thank
Just
you.
wanted to get a head count.
Thank you both. Just wanted to get a head count. We got you. Okay, we can go ahead and.
All right, yep, with that, Chief Inspector Ford, if you could provide.
Most respectfully.
Sure.
Just for the record, we're here on a violation here.
Understood.
So pro and con and support is not relevant.
We just wanted to get an accurate head count. I don't think that the board has indicated that they're going to consider that. We just wanted to make sure that people are heard. We also need to make sure that our sign-in sheets are accurate and accurately reflect all the individuals who are present. All right, well, with that, Mr. Ford, if you could please provide a recitation of facts.
Thank you, Mr. Prairley. Prior to my statement of facts, I'd like to make a motion that my report and all attached exhibits, which have also been provided to the licensee and licensee's counsel, be moved into evidence and become part of the record.
Objection, Mr.
Object to that. This is the report, as I understand, that's been submitted. It's a one-page document of March 4th. But then there's a compilation, a summary, if you would, of incidents going back to June of 2022. They're not reports. They're a resuscitation of hearsay.
Okay, your objection is noted, but everything will be accepted, Mr. Ford. Thank you.
Thank you. So this is by Chief Inspector Ford. Activity date was 2/29/24. Report date 3/4/24. Magothy Inn, located at 546 Center Street, Pasadena, Maryland, 21122. Due to multiple complaints, see attached, and after months of working with licensee Paul Paish and complainants Catherine Vueg Taylor and Todd Taylor to explore solutions to various issues associated with those complaints, I made the decision to issue citation number 1277, delivered to the licensee by Inspector Ace Chenoweth on February 29th, 2024, pursuant to the restriction on the outdoor service in the beer garden area that no complaints are received and no one is disturbed. End of report.
All right, thank you, Mr. Ford. Mr. Bittner, questions?
No complaints alleged by the Taylors were sustained or found to be credible by any of your inspectors, correct?
To the best of my knowledge, that is correct as of the date of this report.
And that's all we're talking about is March the 29th and prior.
Correct.
February 29th and prior.
That's correct.
In fact, those complaints encompassed the 13 separate occasions that inspectors visited this establishment since 2022 through April 16th of 2024.
Correct.
No other questions?
Okay. Mr. Chairman, questions?
Mr. Paish.
Just for Chief Inspector.
I'm sorry.
Ford, not a problem.
Yeah, I'm jumping the gun. I apologize. You sent the inspector out with what intent?
To investigate any complaint received as we were able, whether it was noise or unruly patrons. Basically, those were the two biggest complaints from different things like even air conditioning units, which I worked with the complainant and Mr. Paish to get fixed, again, to the best of my knowledge. I believe that the complainant would acknowledge that it's fixed, at least in part. So, yeah, to try to resolve the issues between the parties.
So would it be fair to say that you sent the inspector out there because of information that has been gathered or grouped, that you felt that with the restriction that was on the license that was in front of you,
Yes,
that it needed to be investigated?
that's correct.
Is that what I'm hearing? Okay.
Correct.
All right. No further questions for the chief.
Thank you.
Commissioner Duffy, any questions? Mr. Ford?
Question for the chief.
Commissioner Snoops? No questions. All right, Mr. Bittner, we'll turn it over to you.
Well, if I may follow up to the chair's question.
Sure.
No violations were found when your inspectors went out, correct? You didn't charge any separate standalone violation for any conduct of the inspector, conduct of the licensee based on these purported complaints.
Correct.
You made reference to a complaint about a noisy air conditioner.
I meant refrigerator. Yeah.
Refrigerator,
Yeah.
air conditioner.
Yeah.
That's when there was, the refrigeration unit was broken and it needed a piece to repair it, right?
Mm-hmm.
And my client had ordered that piece and it was on its way, right?
That's what I was told.
Right? And it was repaired.
As far as I know of, it was.
And please, where in any rule or regulation is noise from a temporarily broken refrigeration unit a violation of any liquor board or alcohol, cannabis, tobacco, alcohol beverage, whatever it's called now, violation?
Notwithstanding the restriction on the license, that would be correct.
Okay, so here's a restriction on the license that says that the licensee can't have a complaint, right? That's what this restriction purportedly prohibits.
Yes.
So you're not even sure what the restriction purportedly prohibits. Is that right, Chief?
Well, no, I think it's related to the outdoor area. I think I can tell you the intent, but you would be correct that it's a little vague, in my opinion.
Okay.
I do believe the intent was, and I'm going to say it, when the outdoor service was granted, I think the previous board probably wanted to make sure that the community was being kept quiet with the granting of that service.
So you would agree with me that the board can't delegate its regulatory authority to the community, can it?
Ask that a different way.
Who decides when there's a violation, the board or somebody calling up with a complaint?
The board.
Thank you.
Mr. Chairman, anything in follow-up?
No questions.
Commissioner Duffy, anything in follow-up?
No question.
Commissioner Snoops? No. All right, Mr. Bittner.
I don't have any questions. I don't have anything evidence to present. I think I've renewed my motions for no action, for dismissal. This matter's been fully litigated, and the evidence produced here in support of this violation, alleged violation, shows no violation, no conduct on the part of this licensee that rises to the level of a violation, and doesn't even purport to put him on notice of what he did to commit a violation. So there's just no evidence of any improper conduct, violation of any rule or regulation by this licensee. And I'd ask you to take no action.
All right, thank you.
Sorry about that, gentlemen. Mr. Bittner, you bring up some points that I think are somewhat valid. It's what I'd like to do, what I'd like to see happen is for that this restriction be revisited and reworded so that it is clear and not so easily, if you would, violated by a simple phone call or a complaint. I don't think that would be fair to the licensee. But at the same time, I do know that there is some, reactions in the community and some things. If I were to make a motion to dismiss this particular charge, would you be willing to, I don't know what's the best way to put this, be willing to, as far as a rewritten restriction, would that be something that we would need a hearing?
We would need a hearing on it, but it might be something, and obviously we're not giving legal advice to Mr. Paish or to his attorney, but it could be that the licensees would file a request to revisit or reword the restriction, and then we could have a public hearing on that if that's something that the licensee would entertain. But that's one of the options.
Yeah, we're trying to make this work for the licensee as well as the community. So is this something you think a licensee would entertain?
Mr. Chairman, I don't know. I haven't discussed it with him.
Okay, understood.
And I wouldn't even think about trying to have that conversation right now.
Sure.
No, and I understand that. Okay, I'm going to make a motion, and because of the wording, ambiguity of this restriction, the way it's written, I'm going to make a motion that we dismiss this charge, and I'm looking for a second.
I'll second the motion.
Okay, thank you very much, Commissioner. I have a second. All those in favor?
Aye.
Aye.
Thank you very much. And I'm sure Mr. Praley and I can talk about whatever proposal the board has. And let me just say this. Chief Inspector and the whole staff here, I believe, has worked in good faith with my clients to try to resolve these issues. But most respectfully, Mr. Chairman, these are just frivolous, scurrilous issues. Okay, these are not real issues. That it's a paranoid litigant that chose to move next door to my client, and I can't say any more about what his legal strategy is in that regard.
Okay. All right. Case is dismissed.
Thank you.
Take care, Mr. Paish.
Thank you, gentlemen.
Mr. Bittner.
Thank you. Thank you very much.
Okay. Our next case is Sidelines, U&J Beverage, Inc. Mr. Kodensky, would you mind waiving the reading?
I will.
Thank you, sir.
Thank you.
If you could all remain standing and raise your right hand. And by the way, thank you for appearing again, having received a request from us to appear. So we appreciate it. This is Uma Runabat, President, Santosh Parash, Assistant Secretary, Inspector Jacqueline Alsup. This is a Class H beer, wine, liquor dancing. You waived the reading. So I'm going to swear you in. I'm still thinking about the last
Been
case.
sworn out enough times, but you.
Please raise your right hands. Do you solemnly swear and affirm under the penalty of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Yes. Thank you. You may be seated. And Inspector Alsup, if we could start with your name and Address, please.
Jacqueline Alsop, Inspector, Anne Arundel County Liquor Board.
Thank you.
For the record, Melvin J. Cadence representing the licensees.
Thank you, sir.
Umarana Bhatt, 822 Bynum Hooker, 21009.
Thank you.
Jyoti Ranawat, 8222 Bynum Viewport, 21009.
Thank you.
You know, when I look at this case, I think I must have like a death wish here. I happened to be in the hearing before 416 that went to 11 o'clock with Mr. Bittner. I don't know whether he likes me or doesn't like me or whatever it is. And at that point, the protest was dismissed, and there was not a request made at that time with the renewal of the dancing and the entertainment section. But all that being said, that's what we're here for today. They asked for it to be renewed for the up next year in this matter.
Mr. Chairman, do you have any questions?
No questions.
Commissioner Duffy, any questions?
No question.
Commissioner Snoops?
No questions.
All right, Mr. Kadensky, anything you want to add?
No.
This is a tough one. No. Okay, what we have here is a restriction that was put on 2/11/2014 with the license saying that the dancing license must be granted annually, right, by the board at the time of renewal. The dancing license will not be automatically transferred with the license, but must be approved by the board at the time of the transfer. It was missed, and I'm sure it was inadvertently and accidentally, and that's well and good. The situation with sidelines is there has been some concern from the local community about the establishment prior to you taking over the license. And if I can, I'm going to ask for a show of hands in this case too, to see if there's anybody here in support of or not in support of sidelines. Is there anybody here in reference to the sidelines license? No? None? Okay. Well, that answered that question. It is important that you understand your obligation to make that request. And I understand you've done that in the form of a letter, so, but the timing is important too. So we want to make sure we do it before the renewals, and that way there the board will have a chance to rule on it and, either agree or disagree to extend it. If I may, while I'm taking this opportunity, I feel that it's only right to forewarn you that because of the protests that came before us previously, that you're going to have to be extremely careful with that dancing license because it can be taken away from you as easily as it's granted with cause. And I think that's important that that you understand that. And with that being said, I'm going to go ahead and make a motion. We leave the restriction as is and move on. Looking for a second.
I second.
Thank you. All in favor?
Aye.
Aye. Okay. Well, thank you for coming in, and we'll see you in about 9 months or so.
All right. Thank you.
Thank
Thank
you.
you.
Have a good day.
Saved my marriage.
And Mel, I did that just for you.
I'll tell my wife when I go home that she's up.
He was here early. I came in here before 5, and he was sitting out there waiting.
I was ready.
We didn't kill a few minutes.
You're back here?
Got money in there.
We'll bring it.
I dropped 100 here, so if you find it, call me.
All right. When he gets home, his wife will point that out to him.
Thank you.
Thank you.
Our next case is Duffy's 3. Duffy's 3, WC Inc., Falguni Nimishkar Patel, President.
We'll waive reading. Are we calling items number 8 and 9 at the same time, or are we calling just the suspension review first?
Suspension.
Yeah, let's do the suspension review first, and then we'll do item number 9 next, the violations.
Okay, if you could remain standing. Raise your right hand, please. Do you solemnly swear and affirm under the penalty of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth? Thank you. And Inspector Maloney, if you could begin by stating your name and address for the record.
John Maloney, Anne Arundel Liquor Board.
Falguni Patel, franchise, Duffy's 3.
Thank you.
And I'm Brian Lyman, Lyman, on behalf of licensee.
Okay. All right, Mr. Lyman, we'll turn it over to you for the suspension review. You can present your case by proper testimony or combination of both.
Thank you, Mr. Fraley. Unfortunately, I'm going to have to go into a little bit of the gory detail about what's going on at Duffy's 3. Really, this begins when a construction case went poorly for the landlord and appropriate permits were not obtained by the contractor. I will not rehash for the board what I'm sure it can remember from our presentation at the violation hearing where the suspension was issued. However, I do think it's pertinent to mention that on June 15th, 2023, Ms. Patel filed a downgrade application to change the class of her license from a Class B license to a Class A license. And we understood that the board would be hearing that change of class application tonight. However, it does not appear on the docket tonight. We have served the suspension. There was a 90-day suspension issued in March. March 13th was a 90-day order of suspension that was issued. Ms. Patel went forward and filed a court case in Anne Arundel County Circuit Court. Mr. Praley represented the board in that case, and we agreed by consent injunction signed by Judge Schaefer on April 15th that the board would consider the change of class application at its next available hearing, which we maintain should have been now. Because of course, Ms. Patel cannot open a Class B establishment because, as everyone well knows, there is no kitchen at the building. There are no permits to build her a kitchen at the building. And the landlord had some health and safety issues and problems with moisture entering the building and problems with the roof that the landlord needed to remedy, which were detailed at the last hearing, where the suspension was levied, and one of the charges was safety and sanitation. This establishment has not been open since the day after that hearing. And so I have provided the board with a letter on June 19th, providing photographs of the before and after. I'll be happy to introduce those as Exhibits 1, 2, and 3 for licensee. And I believe I provided this to the board previously, so hopefully the commissioners have a chance to review the photographs. A photograph says 1,000 words, which is good because that way I don't have to say the 1,000 words for each of the roughly 45 photographs that are in the exhibit package. I will generally characterize those photographs as saying or explaining that Duffy's was in need of serious repair and maintenance, including painting and some minor electrical work, and those things were accomplished almost immediately by the landlord in this case. OGEL LLC, Mr. Patel, Dinesh Patel, appeared and spoke before the board at the prior hearing in March. And we believe that we were on track to have our license application heard for the change of class. As I indicated, that application we believe has been ripe and pending since it was resubmitted to the board in early August 2023. And Ms. Patel is frankly frustrated that she is still closed because this is a situation where we agreed to continue the suspension via emails with Mr. Praley to put these matters together on the same docket. And I'll hand up Exhibit 4, which is the email communications. I like that marked and entered into the record. These are the June 18th communications with Mr. Praley about consolidating the two hearings, both the I suppose that it was called a show cause in our communications back and forth. And at that time, we were only newly aware of what is case 9 on this board's docket, the alleged violations, which frankly, we're still trying to figure out what those violations are for. And I share Mr. Bittner's sentiments that he expressed previously, that it's difficult to understand what's being charged sometimes by this board or by the board's inspection staff. That being said, we believe that Ms. Patel is a fit and proper operator for a Class A license. We would ask the board to appropriately advertise her change of class, as we believe the court order indicated would occur, and to lift the suspension and allow her to open. She has had Duffy's 3 closed for well in excess of the 90-day suspension that was issued by the board. That suspension was served, and we believe that we would receive a hearing at this hearing date for the change of class. And we don't entirely understand why that hasn't happened. I'm going to hand up exhibit number 5, which is a June 10th correspondence from Ms. Hagner, instructing me to make sure that we picked up the advertisement sign by June 29th, which would be 10 days in advance of tonight's hearing date, for the change of class hearing. And I don't know how much more I have to say in our presentation on the suspension. We believe the suspension was served, a de facto suspension well in excess of 90 days has already been served. And frankly, Ms. Patel is owed a fair hearing on her change of class application that was filed last August. And apparently she won't get a hearing on that application for a year. And in the meantime, we have had allegations and violations alleged and found by this board that are less than clear to us. And that's what case 9 is about. So I'll leave it there. If the board has questions for Ms. Patel or me, I'll be happy to answer those questions. But we were disappointed that the board did not put the change of license class application on tonight's docket. And we're awaiting an explanation about that, frankly, so that we can understand what this licensee is supposed to do next to open her establishment and, again, serve the public alcohol at Duffy's 3 location. Thank you.
Thank you, Mr. Lyman.
Thank you, Mr. Lyman. If I may, I have in front of me the findings of that board in which I made a motion to do the suspension, and it reads as follows. It says the board has decided to suspend a license for 90 days, allowing the licensee to come back at the end of that period to address the board as to the present condition and progress. And as far as I know, we haven't received that request. And also, it was not the intent of this board to grant or end that suspension unless she had all of the proper documents required by the county, whether it be inspections and permits, the health department, the fire marshal, etc. We contacted your office, I believe, and made mention of the fact that the suspension was up on or about June 10th, I think it was. And we did inquire as to whether she was ready to proceed, meaning did she have what was required in order for this board to approve that. So I think that's the understanding that I had, and according to this, that was what I meant when I said you have a 90-day suspension. Hopefully at the end of that 90 days, you can come back in front of the board, show us that you got all the required permits and licenses and so forth, and then we could move on. I know of nothing that was presented to us saying that that had happened. Now, since then, and I'm not going to go into the violation, but since then, an inspector went out on the premises and evidently brought information back to the chief, which ended up in reference to a violation. Now, let me ask a question. Does she have all the permits that are required going back from the suspension? And if the answer is no because of the change of class, and that's the reasoning behind it, then I'm going to explain to you that I, as chairman, and I discussed it with the board, decided not to hear that case tonight because we had an open violation. We cannot take action on something when we have an open violation. We have to close that violation out, bring it to a conclusion. So tonight you have two cases. One is the suspension and the other is the violation. After tonight, I'm assuming everything will be finished and we can move on to the change of class.
So maybe I'm confused, Mr. Chairman, because I heard you explain that the licensee was going to have to review or request a review of the license suspension. And you have no request from the licensee to review the suspension, and yet that's what we're sitting here talking about for item number 8 on the docket, correct?
Yes, because we asked you and your client if they were ready to do something. We did not hear anything by the end of that 90-day suspension period saying, hey, we'd like to come in front of the board. We have our...
Okay, so this may have nothing to do with the licensee. It may have to do with my representation of my client, because I understood that we had a consent order signed by a circuit court judge that established what the procedure was going to be in order to evaluate what was going to happen with both the suspension, which was mentioned in the consent order, with the change of class application, as well as I'm not sure what permits or issues needed to be abated in the board's mind, because I don't think it was established clearly in the record at the hearing in March that these issues, permits, matters needed to be properly handled with the regulatory authorities, that being inspections and permits or what have you. Whether, I mean, she has her health department license. She has all of the other permits from the fire marshal, but we haven't requested a review of the suspension because we can't get the change of class application heard, and she cannot open the establishment until she gets a different class license. So I apologize if I'm feeling or I appear frustrated, but this seems like a big miscommunication to me. And again, I don't understand what the violations are for, because the establishment has not been open to the public. She doesn't have to staff the premises. She doesn't have to have anybody there. The doors are locked. The license is at the liquor board. She doesn't have a license to have violations happen under right now. She needs to have her change of class application heard by the board, appropriately adjudicated, and then maybe if she gets a license to hang on the wall, she could be subject to sanctions by this board again. Right now, it's just a building in Lothian. So that's what we're confused about.
I can understand the term confusion here, but at the same time, I thought we made it really clear at the last hearing that because of their failure, they meaning the landlord and Mrs. Patel, or the landlord and in by himself, failed to get the appropriate permits and inspections. And it was because of that and several years of involvement that they got a suspension. And it was the intent of this board to say, we're going to suspend your license for 90 days, and at the end of that, hopefully you'll have whatever you can to be able to present to us for us to lift that suspension. Have not heard about that. We even went as far as to try to we did contact your office, and we tried to get something set up so that we could make sure that this just didn't run into months and months and months and nobody doing anything. And then while that happens, evidently, somebody was inside of that building, and somebody was doing work in that building. And I don't know if it was open to the public. I tend to believe that it probably wasn't. But it came to the attention, and that's what this violation hearing that's coming up is going to bring to some kind of conclusion. So I'm going to need a moment with our attorney. Excuse me.
Mr. Chairman, if I may just interject, it seems to me that my client hasn't requested a suspension review. The license remains in possession of the liquor board, and she's served a de facto suspension, which continues to this day and will continue until she gets a hearing on the change of class, which is why we're confused why there is, a penalty and violations that are coming up or alleged when the establishment has not been open to the public, and all that's happened at the establishment is attempts to repair the facility in order to comply and obtain all of the necessary approvals for the board. So I'm previewing the defense, but my suggestion is that the board take no action on the suspension, which is de facto, and hear whatever the alleged violation is, but we still don't understand why it's the licensee who's alleged to be in violation when she doesn't have a license. That's our logic on this issue.
Mr. Lyman, question for you. Is the establishment ready to open today or tomorrow?
I believe that all of the permit issues that maybe we'll hear about later will be resolved in the next day or two. Frankly, the problem with inspections and permits is that there are several different units, and there's lots of pending applications for this property. And there were many comments from several of the departments that had nothing to do with the minor repair work. And there's a roof repair in particular, which is the permit that I believe was determined after the fact was required. And that they wanted a structural engineer to supply sealed documents or sealed plans that certified the structural integrity of the roof. That is what the hang-up was. And I believe that issue has been resolved with inspections and permits, except that we don't actually have the permit issued certifying the premises to be opened, which is why you don't have a request from the licensee to review the suspension. But the existing premises, we believe, will be able to be open within the next few days, if that's your question, Mr. Chairman.
Okay, let me run this past you. If we, you say, if we allow the suspension to continue for now and listen to this next violation case, we may develop information from that, because I understand we have somebody from inspections and permits who is familiar with the case is here, and then we can find out what the status is. Continue the license as a B for another month, and then we'll put it on the next docket. for the class change.
Respectfully, I would urge the board to do that to avoid contempt of court.
Thank you, Mr. Lyman. But do you understand the process? Allow, if inspection and permits.
I have no objection to that. If we can obtain factual information from inspections and permits about the issuance of all necessary permits to have the doors open to the public again, I think that would benefit the board as well as my client. To be candid, this is not my client's responsibility. It's the landlord's responsibility. So.
Did you bring the landlord in?
The landlord is not a licensee. He's not required to be here.
Okay, but, okay, that's fine.
I'm just saying, you're trying to hold the licensee responsible for something that's the landlord's obligation, so.
Okay, so what we're going to do is we're going to leave the suspension in place, intact, and then we're going to go on with case number 9, which is the violation, and then we'll take it from there. Now, we'll continue the license under the B status or class, and then once we get the violation out of the way, then we can set up the change of class for the next available date. Mr. Aronson will have to try to find a way to fit that in. Okay? I believe they may
Thank you,
even...
Mr. Chairman.
I'm sorry?
I just said thank you, Mr. Chairman.
Oh, yes, sure, of course. Okay, so for now, this case is continued. And I'm going to call the next case, which is number 9, which is the violation. Chief, if you would, I think we have the same people at the desk or table. Go
Yeah,
ahead.
the next case would be Duffy's 3.
We can waive that reading.
Thank you.
Thank you.
If you could please stand once again. Mr. Malone. Raise your right hands. Do you solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth? Need to pause because I'm in this one. Yep. We also need Mr. Mathesius from Inspections and Permits.
Yes, he will be testifying.
Matthias.
Mathesius.
Mathesius.
Okay, do you solemnly declare and affirm under the penalty of perjury the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
If you could state your name and address for the record.
Chief Inspector Jim Ford, Anne Arundel County Liquor Board.
John Maloney, Anne Arundel County Liquor Board.
Leonard Mathesius, Chief Building Inspector in Arundel County.
Falguni Patel, Duffy's 3.
And again, I'm Brian Lyman, Lyman, on behalf of the licensee.
All right, Mr. Ford, who's going to be providing a statement of fact?
I will begin.
Okay.
And prior to my statement of facts, I'd like to make a motion that my report and all attached exhibits, which have also been provided to the licensee's counsel, be moved into evidence and become part of the record, please.
Objection, hearsay.
Okay, those will be admitted.
So, Mr. Lyman, I need to begin with an email that you should have that's dated on February 23rd, 2024. It's from you to me at 4:06 p.m. Jim, I have has occasion to discuss Duffy's 3 with my client in preparation of the case for the March 12th hearing. I understand that they are reticent to do and have not done what should be basic maintenance at the property because of the former chief inspector's instruction that they stop all work pending permits. I stopped by the property this week and was shocked to see the condition and appearance that the licensee is suffering through. I told them that they should paint and fix the sign on the rear of the building, replace the ledge shelf at the drive-through window, and a few other items. But they were concerned that doing those things would result in violations from the board based on Chairman Harris's prior comments to them when he was chief inspector. The property looks lousy. My clients are willing and anxious to do just the basics, get the peeling paint cleaned up, and fix their signs. I trust that wouldn't be a problem. Please confirm. I replied to you at the same day at 4:41 p.m. and said the following. I'm not opposed to any of that, with the caveat that any improvements that would require a permit would have to go through those proper channels. Obviously, a lot of basic upkeep doesn't fall under IMP, but if in doubt on any particular project, they should check with IMP. But yes, they have to begin somewhere, and I agree there may be some low-hanging fruit that won't require a permit. Have a nice weekend. Now I'll read my report. Report date is June 11th, 2024. On Friday, June 7th, 2024, I was informed by the Chief Building Inspector for Anne Arundel County, Leonard Mathesius, that certain work had been performed at the Duffy's 3 establishment that required permitting. Mr. Mathesius informed me that the licensee had not obtained such required permits. As a result, I directed Inspector John Maloney to issue citation number 1751 for violations in connection with 3.02 cooperation, 3.05 sanitation and safety, and 4.16 unauthorized conduct. The citation was delivered and executed on June 10th, 2024. And you mentioned earlier tonight that our violations aren't clear. Well, that's clear as day, sir.
Anything else, Mr. Ford?
No, thank you.
Mr. Lyman?
What conduct is alleged to have been done in the licensed premises that violates the board's rules, these 3 rules?
I defer to Mr. Mathesius
So
on that.
you don't know?
I was told there were some structural issues.
Okay,
And I'm not a member of inspections and permits, so I have to rely on his expertise.
Okay, so you didn't visit the premises to see what had been done, correct?
Not at that point, no.
Okay, and you,
But I've been there many times before, and I've seen how you described it.
Okay, nevertheless, you instructed your inspector to issue a citation, correct?
Correct.
Okay, and that was based entirely on the information you received from Mr. Mathesius, correct?
Absolutely.
Okay, and what information did you receive from him?
I was told that they did not have the proper permits.
For what?
For what he can describe as structural deficiencies or work that had been done that was not permitted that required permits.
Okay, work that was done when?
I would have to defer to Mr. Mathesius.
Was it done before the prior violations?
Unclear.
So you don't know?
Unclear to me.
Okay. And so...
But I would ask if they had the proper permits for that work, regardless of when it was done.
We already had the board decide that they didn't have proper permits for that, and that resulted in a suspension of the license, right?
I would defer to Mr. Mathesius on when the work was done.
But you didn't ask Mr. Mathesius before you instructed your inspector to issue the violations.
I did not.
When the alleged work was done that violated the code, right?
I did not, correct.
And that's not in your report either.
It wasn't in the information you gave me either.
No further questions.
Mr. Chairman, questions of Chief Inspector Ford.
Chief, when this was going on, did your inspector or anybody tell you that they were actively inside of the building doing work? Did Inspector Maloney report to you or anybody?
He did not. I had seen them, I had been there myself a number of times and seen them doing cosmetic work. I didn't see any structural work.
Okay, no further questions.
Commissioner Duffy, any questions of Chief Inspector Ford? Commissioner Snoops? All right. Mr. Maloney, do you have anything you want to add? Do you have a...
At this time, not really.
Okay. Makes the questioning easy on that one. Mr. Mathesius, thank you for being here tonight. Do you have a statement of facts that you'd like to provide the board?
None unless you have any
Hold on.
questions about the
Excuse
structure
me.
or permits or anything that needs to be taken care
I'm
of.
sorry. Excuse me. Okay. I'm going to interrupt you just for a second, sir. Inspector Maloney, did you notice at any time that if anybody was in that building when you were in your area riding around doing any kind of work?
No, I noticed that early on there might have been some people I didn't notice any work going on. A number of times in April and in March, there was no activity whatsoever that I witnessed. And I have reports to back that up, but I don't have them with me.
Okay, thank you. Mr. Mathis, I'm sorry.
Mr. Lyman, do you have
Mr.
questions
Lyman.
based on that?
Inspector Maloney, what frequency did you go by Duffy's, just generally, during this period, during the suspension?
I would have to say probably a half a dozen times.
Okay, about 6 times in 90 days, give or take?
Yes.
All right. And you didn't see work being conducted at the building at all?
The work that I saw was mainly cosmetic. I'm not sure the dates, the times, but we've had pictures of that, painting the sign, painting the outside. General cleanup work was being done, but nothing inside.
Okay, and Mr. Maloney, before you issued the inspections instructed by Minister Ford to be issued, did you do any investigation or follow-up on the allegations?
I did not.
Okay, so you didn't call Mr. Mathesius or anybody at inspections and permits?
I did not.
Okay, did you check any of the publicly available building permit and inspection records?
I did not.
Thank you, no further questions.
Any follow-up based on that line of questioning?
No, none.
Okay.
None by me. Thank
Commissioner
you.
Duffy, Commissioner Snoops?
No.
Okay. Mr. Mathesius, sorry to cut you off earlier, but go right ahead.
Not unless you have anything that you need specifically answered, but there has been no, the building is currently under an unsafe structure notice. I did indeed ask for structural engineer to evaluate the building due to the wet conditions and a roof collapsing and the existing electrical getting wet in the back where it was leaking. Also, the refrigeration units, that was another reason why the building was posted unsafe. The permit was applied for, but it is just sitting there now, waiting for, I'm assuming, the person who filed for it to answer the questions from the county on extra proposals to put into the county and answer the questions on what they need.
Mr. Lyman, questions?
Mr. Mathesius, when's the last time you checked the permit status?
This morning.
Okay, you didn't check it before this hearing, after today?
I checked the first thing this morning
Okay.
at 7:19.
All right, so you wouldn't be privy to any additional documents filed today, correct?
That would be correct.
And what were the outstanding issues that you were waiting for comments on?
I do not know. I'm not privy to that part of the computer system.
Oh, so you
All I know is we're waiting for a revision as needed from well, septic plan and fire review for additional information.
Right, but those are in reference to a grading permit, right?
That is, no, that is for the repair, the replacement of the roof in the back between the building and the existing storefront.
There's a well septic comment required for the repair of the roof?
It goes through the channels, yes, it goes through all the proper channels.
All right, so how long has that been pending?
That is usually two-week turnaround, and it was due on 7/1.
But you don't?
And, excuse me?
Do you know what the comment is? What's been
No, I do
unanswered?
not. I'm not privy to that part of the computer system, what the comment was.
Okay, what else can you identify that was pending or awaiting comments on?
That would be fire review, and that would be plan review for that.
All right, so what is the scope of fire review?
Do not know the scope of the fire review either.
Okay, how about the plan review?
Plan review, I'm assuming there was comments for additional information needed for the structural part of the building for the permit.
Okay, but I don't want you to assume, I want you to testify to what you actually know of your own personal
I can't tell you that because I wasn't privy to that part of that information.
Okay, so you've looked at the computer, but you can't explain to the board what the substantive issues are and why the county hasn't approved the permits, correct?
That is correct.
When's the last time you inspected this building?
Last date I rode by was April 22nd.
Okay, and do you recall the first date that you inspected this building?
More specific, please, because I've been at this building for a couple of years now. Are we talking just at the liquor store, or are we talking the front of the building, the whole property?
Going back several years, are you the inspector who placed the unsafe structure notice?
That's correct.
Okay, when was that placed?
On which part of the building? We talking liquor store, or we talking the front of the building?
I'm talking about the liquor store. Is that still under an unsafe structure order?
That is correct.
Okay, what was that notice placed?
That notice was March 16th of '24.
March 16th, 2024, you inspected and placed an unsafe structure notice, correct?
That's correct.
Okay. What was the prior date that you'd visited the store prior to March 16th?
We were there several times through complaints, through the complaint system of the building falling down in front. We've made them put up fences. We've made them maintain the fences. We've gone through tours inside the building several times with the landowner. I can't tell you the exact dates because they were just random. We randomly went there for them when they called, and we would make a random inspection per the request of the fire marshal or a complaint that came in on the complaint system.
Maybe you can explain to the board what was different on March 16th that you issued an unsafe structure and order that day versus your prior visit.
The fire marshal had asked me to visit the premises because he went there to do an in-service call for the establishment, and he called us down there, the chief electric inspector and myself, to come and look at the wiring getting wet and the roof falling down in the back. Then we took the tour of the building and made determinations then. Okay, and how long was it before March 16th that you had previously visited the liquor store part of the building? A couple of months. We also had a meeting at the building with the landowner and the architects and everything, and we discussed the roof leaking at that time also because they're preparing to put an addition in front of the building. So we discussed the liquor store at the same time. All right, but you didn't issue at that time an unsafe structure order, correct? Yes, the front of the building had an unsafe structure on it, yes. Yes, but the liquor store portion did not, correct? It did not. They were working expeditiously with us to repair all the major electrical issues that were in the building, and we were giving them time to repair it. And we worked it out where the electrician would call our chief electric inspector, and he would go there randomly for them as they got the work done. We did not want to close the liquor store. We were trying to work with them to keep it open so the business didn't fold. Okay, and so on March 16th, you'll agree with me that the liquor store was in fact closed, correct? The liquor store, the day I posted it, the liquor store was closed. I was there. Have you been back by the premises since March 16th? I think you said in early April? Yes. All right, was there any activity at the premises then? No, there was not. Okay. Can you identify what work has been done since you posted the unsafe structure order? No, I cannot because I've not been back in the building. All right, so you don't know what work was done or not done in reference to this building, correct? No, I spoke to an engineer and he said that he was working on the building, and that's when I brought up the building permit, and he said he did not obtain a permit to do it. To do what? To repair the rotted roof that they replaced in the building. But you've seen the roof replaced? No, I have not. I want to hearsay from the engineer. Okay. No further questions.
Mr. Chairman.
I guess I'm curious as to what work was performed, if any. Mrs. Patel, are you contracting anybody to do this work inside of the building, or is that the landlord, Mr. Patel?
The landlord.
The landlord? Mm-hmm. You have no control over who goes in and does what work in there? No. I mean, as far as the reconstruction, renovations, and repairs? Okay. When was the last time you were in your building?
Last week.
Okay. Did you notice any work that had been completed since the previous time, and when was that?
You can answer if you know.
Not really.
I'm sorry?
Not really. I didn't see any.
Not really? Okay. Mr. Mathesius, what is still open in order for her to be able to open, let's say, the liquor store, the cut rate portion of that building? Do you know whether it's all electrical or plumbing or building, or just, do you have anything that you could enlighten us with?
Well, seeing it's a permit hasn't been issued yet, we haven't been called back there for any inspections to go inside and determine anything. And I'm sure more electrical work was done in there when they tore the actual roof off. So we don't know if they obtain a permit for that either. That's what we'll have to, if we can get in the store, I'll be more than happy to go there and make a visit for Mr. Patel and go in the store and look if somebody can be there and see
Objection,
how it
move to
sits.
strike. Mr. Mathesius already testified he didn't know if the roof had been done. He's speculating about additional electrical work that's inappropriate for the board to consider. He doesn't have personal knowledge of it.
Okay.
It'll be overruled, but we'll.
Is that
Do you have any,
overruled?
yeah, do you have any other questions, Mr. Chairman?
No further questions at this time.
Commissioner Duffy, do you have any questions? Commissioner Snoops?
No.
Mr. Lyman, do you have additional questions of Mr. Mathesius?
No additional questions. Thank you.
All right.
I'll be happy to make a closing argument if you want to hear it.
Oh, yeah,
I think we
please.
will, yeah, absolutely.
In sensing the tenor of the board, I would just ask the board to really look at the three violations that are alleged here. We have a violation for section 3.02 cooperation, which apparently is probably on me because I didn't understand that I had to make a response to the board specifically asking for a review of the suspension for 90 days at the conclusion of 90 days. And that's my fault because I understood we had a consent order entered in the court case that addressed the timing and the scheduling of the hearing. And only after the hearing could we actually legitimately request a lifting of the suspension. So if there's any lack of cooperation with the board staff, it's because the queries and requests to my office were misunderstood by me. And I think that it's inappropriate to hold Ms. Patel responsible for that. And my misunderstanding of it is because I didn't understand that we hadn't already dealt with the request for cooperation with the board in the court case and with the landlord diligently pursuing only painting, light repairs, and working through any structural issues and repairs that required permits with the permit department. The permit fees were paid on June 10th by the landlord, and they were modest. They're only $115. I think I detailed that in my letter to the board. The issue is, I think, with the structural certification of the roof and the members holding up the roof. And that is really, I think, the only thing that a permit's required for this liquor store portion of the building. We've heard testimony from Mr. Mathesius that he knows some of what's going on, and he's seen the premises, and he's, in fact, the inspector who said that the structure was unsafe. But there's been no public occupancy of the structure. There's only been some folks in and out to deal with those issues in an appropriate manner to assess and apply for the permits and to have the engineer answer the necessary questions from the various departments at the county to get the permits that are required. And so I need to apologize to both my client and the board because I misunderstood the 90-day deadline as being a deadline that we had to make a showing back to the board or schedule a presentation to the board. And that's my misunderstanding. I believe that we would address the suspension at the appropriate time along with the hearing for change of class. So that's perhaps what you perceive as lack of cooperation, and it's not the licensee. It is her lawyer misunderstanding what the demands were from the board and not responding in an appropriate manner, apparently, okay? Beyond that, I would say that that's not a violation because in good faith, we have been participating with both boards' counsel in the circuit court case. We have been supplying updates to the board voluntarily with photographs and documents that we would like the board to consider on behalf of the licensee pending review of the suspension. But We didn't ask for a review of the suspension because we know that the premises is not ready to open. As soon as the premises is ready to open, we had hoped to have a change of class application heard by the board, but instead we got hit with these 3 violations, which we heard from Mr. Ford. He didn't bother asking what work had allegedly been done. We heard Mr. Matthias doesn't know what work has allegedly been done. And we heard from former chairman, Mr. Maloney, that nobody knows what alleged work had been done that was required to have a permit that didn't have a permit. And so the 3 violations that we're facing tonight were not properly investigated by the board. There are records available, public records on the permit website, and there are appropriate people at the county that you could ask whether they have knowledge about this, or you could demand the information from the landlord and subpoena him to this hearing if you wanted answers on what's happened at the premises. But the case has not been proven. The case has not been proven for lack of communication. The case has not been proven for sanitation safety violation, and the case has not been proven for unauthorized conduct because the board doesn't have any facts in front of it to say, here's the unauthorized conduct that happened on this date, and here's the person who's responsible for it. That can't be my client. She's visited the premises to try to evaluate what's happening, make sure that her inventory is safely still there, and she's been dealing with Mr. Patel to try to figure out when the permits and the work will be finished. And she has not requested this board to do anything other than put her license application to change the class of her license on the docket and give her a hearing to change the class of the license to a Class A license so that she can get into compliance and reopen the establishment. Thank you.
Thank you. If I had any hair, I'd pull it out. But
I'm getting there also, Mr. Chairman. I don't know if you've noticed my new do, but
I was waiting for a comment from you. We have quite a quandary here. We have a situation where we believe the building is still unsafe for occupancy. You want a license back. If we give you the license back, it would be a situation where you have a license, but haven't been approved by the proper authorities for occupancy. And the violations, I understand what you've testified to and what you were able to bring out. I think what we need to do here, because even if we were to be able to hear your class, your change of class, we didn't advertise it. It wasn't advertised based on the reason that I explained to you about getting the violation out of the way. We can remove this violation if the board agrees to do so, which would take that out of the way, but we're still going to have to advertise your class change for the next hearing. It's going to have to be posted for 10 days, as you know. And then I can't imagine me, at least, agreeing to allow any business to operate in a building unless they have been thoroughly inspected and approved by inspections and permits, fire marshal, health department, and so forth and so forth. Do you think your client is anywhere close to that occurring? I mean, are you familiar enough with the renovations that?
I believe that the structural certification from the engineer was submitted today, which Mr. Mathesius wouldn't know about because it was submitted today. I've got a copy of the comments that went in today. I can't explain why it is that they went in today and not whenever, a day ago or whenever. All I can suggest is that we believe that the structure will be deemed to be fit for occupancy, at least before the next hearing date that's available to this board. And that's why I said perhaps I opened a bit on the wrong foot, but we're confused and disappointed that the board pulled the change of class application that we thought we had agreed by court order would be heard at the next available hearing, which is tonight, and that we received communication to pick up a sign for, and then the application was removed from the docket. Because Ms. Patel is close, we believe, to operating the store in much the manner it had been operated for, a long time before the prior violations brought the board it was operating not as a Class B license, but as a carryout only establishment. That situation, we believe that we can return to pending the approval of the rest of the permits to really fix the rest of the building. And that's what we had intended to present at the change of class application hearing, was both the renovation plans as well as the interim plan to operate the establishment as a Class A license, with the rear portion of the building being fit for habitation and approved by all of the necessary permit holders, to have the water leakage and electrical issues, whatever needed to be done, taken care of, so that the building could be open to the public and be safe, pending a much longer review permit process, which is frankly probably going to take 18 months to 2 years, if I'm being honest about that process for obtaining a grading permit and having a soup to nuts redesign of the entire facility and building, which is what they're looking at.
I'm trying to think of the best way to maneuver this and work this so that it gives your licensee an opportunity, but at the same time, I personally know what that building looked like when she was operating it prior to the suspension. And I would surely hope that now it would be in some condition, which will be up to his department to let us know. I'm sorry, go ahead. You want to say something?
I mean, Mr. Chairman, you have contingent approvals all the time for transfers and for new license applications where you approve plans and the building isn't even there. Respectfully, I suggest that something along those lines could be achieved. In this case, we do have to advertise the change of class hearing and have the hearing for the change of class. Absolutely, we're aware of the issues with the building and with the premises, and I would urge this board to trust the Anne Arundel County Inspectors and Permits Department to do their jobs, and if they grant the approvals and we're able to show the approvals to the board, then that's what we're able to achieve, and that we should trust them to do their jobs and to make sure that structures that are open to the public are going to be safe. And I think that those contingencies on any approval of change of class are certainly reasonable. We would consider them, and we're working toward trying to achieve that result as soon as practicable.
First of all, I trust that department explicitly. I've worked with and alongside of them for many, many years. And I'm not concerned about them doing their job or their due diligence. I know they will. What I'm gonna make a motion. I know. Why don't you do this one? Do
you want me to make the motion?
No. Thank you, Mr. Lyman. I'm going to make a motion that we go ahead and give Mrs. Patel her license back, her Class B license back. All right? And I'm going to also waive the requirement, because it's a Class B restaurant, of the food portion. And I'm doing that to reactivate that license so that we can move on to the next step. Now, as far as the violations, I'm going to make a motion that we dismiss these charges. Now, I agree with you that perhaps we didn't have, we meaning the board or representatives, enough to show the board where the deficiencies were. But let me also point out that I can't imagine I, alone the board, would agree to giving a Class A license to a building that is not 100% ready to open to the public. And I honestly believe inspections and permits and the fire marshal and the health department and the various electrical department and various inspectors will help us know when that's the case. So I think with that, the motion would be to go ahead and dismiss the charges for the violations. Go ahead and allow you to have your Class B license, and we're going to exempt you from the restaurant portion. It's only going to be for a short time, because if we don't see any activity, which we hadn't for years, if we don't see any activity, I'm going to make a motion, or I'm going to make a request that you be brought back in front of this board. We need to see progress. And I'm going to ask the chief inspector to stay in communications with the chief inspector for inspections and permits in the various departments over there to see what that progress is. Mr. Lyman, if you could keep the board advised as to progress, that would be a big help. And then we'll go ahead and schedule the change of class for the next available hearing. Again, even if the board was to decide to give you a change of class, that doesn't mean that you could open that door that same day, unless all the appropriate inspections in various departments agree so.
And I was just going to say, for clarity, I think the chairman's motion is Class B license is returned. You can open subject to all appropriate permits, whatever is necessary from the county, waiving the restaurant restriction only until the next hearing date, where we will hear where the board will consider the change in class, which I believe is the second week of August.
Now, that's pending any approvals and inspections from INP. Okay, I put that in the form of a motion, looking for a second.
I second the motion.
Thank you. All those in favor?
Aye.
Aye.
Thank
There you go,
Chairman.
Mr. Lyman.
Thank you, Mr. Chairman. Thank you, Commissioners. Thank you, Ms. Brown.
Yep, thank you. Have a good day.
Okay, we're in the home stretch. Next case is 424 Liquors, Arundel and Sandu Spirits, Inc., Ranjit S. Arundel, President, Gurmeet K. Bueller, Secretary, Inspector Scott Montaigne. This is for a transfer. Currently, Richard Ray Jr., Secretary Treasurer, and Robert Ray, President.
Will you waive the reading?
Yes, I will.
Okay, thanks.
Thank you very much. If you remain standing, raise your right hand. Thank you. Do you solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you very much. You may be seated. And sir, if you could state your name and address for the record.
Ranjit Arundel, 11313 Marlborough Ridge Road, Upper Marlborough, Maryland, 20772.
Thank you.
Gurmeet Bueller, 7660 Roy Street, Annandale, Virginia.
Thank you.
Mark Fulton, 200 Westgate Circle, Suite 500, Annapolis, Maryland, 21401.
Thank you.
All right, thank you, Chief Inspector Ford. Mr. Fulton, we'll turn it over to you. This is your opportunity to present your client's case for the transfer request that's pending. You can do so by way of testimony, proffer, or a combination of both. We'll turn it over to you, okay?
Thank you, Mr. Fraley. I'm going to go forward by way of proffer.
Perfect.
Mr. Chairman, members of the board, good evening. As I said, my name is Mark Fulton. I'm here on behalf of the applicants this evening, Mr. Ranjit Arundel and Mr. Gurmeet Bueller. This is a transfer application for a Class A beer, wine, and liquor license. It has a special Sunday permit as well as wine tasting privileges. The licensed establishment is known as 424 Wine and Spirits. It's a packaged goods store located on Davidsonville Road in Crofton, Maryland. I trust the board has received the applicant's application materials. I would now take a moment to ask that they be incorporated as part of our presentation.
They'll be accepted and incorporated.
I'll also note that earlier this evening, I additionally submitted proof that notice was properly posted at the licensed establishment in advance of this hearing. A little bit about the applicants. Ranjit and Gurmeet are contract purchasers of 424 Wine and Spirits. They are, in fact, the sole owners of Arundel and Sandhu Spirits Incorporated, which is the business that now seeks this transferred license. Over the last 30 years or so, Ranjit has operated a handful of 7-Eleven convenience stores. He's a franchisee of the 7-Eleven company, and in addition, he's owned and operated a handful of Subway sandwich shops throughout Maryland and on our eastern shore. Now, in recent years, Gurmeet has been employed as the store manager of a licensed liquor store here in Anne Arundel County. It is Mayo Liquors. She, like Ranjit, has also experienced operating and managing a Subway sandwich shop throughout the years. And so together, I think these applicants have a wealth of knowledge and experience in operating convenience stores and experience in the retail food industry. And both applicants are, in fact, certified through alcohol awareness training courses. I have those certificates. Ms. Agner, if you wouldn't mind accepting these. At this point, I'll note that neither applicant currently possesses any financial interest in any other licensed business in the state of Maryland, and neither applicant is a license holder of any other establishment. The applicants have no plans to alter or amend the existing floor plans at 424 Wine and Spirits. They're aware that a management agreement would be needed if there does come a time at which the licensees are not present at the licensed establishment. And they're additionally aware that upon becoming a licensee, they'd be responsible for any liquor license violations brought by the board, and they would need to appear before this board and answer on the established premises behalf. To that end, the applicants have reviewed and are familiar with this board's rules and regulations. And now with the board's permission, I'd like to briefly turn to my clients just to verify that this proffer has in fact been correct.
Sure, go ahead.
Ranjit and Gurmeet, is the application and all supplemental documents that have been submitted to the board in this case true and accurate?
Yes, true.
Has my proffer this evening of your testimony to the board been accurate and complete?
Sure, true.
Have you received and reviewed the board's rules and regulations pertaining to the service of alcoholic beverages?
Yes. Yes.
And will you at all times have a person on premises who's trained in alcohol awareness program?
Yes.
Mr. Chairman, members of the board, I don't want to make this any longer than it needs to be. We submit that this application meets all criteria required to approve the transfer of this Class A beer, wine, and liquor license for 424 Wine and Spirits to the applicants before you.
All right, thank you, Mr. Fulton.
Okay. Thank you, Mr. Fuller. I do have a question for everybody out there. Is there anybody who is either for or against the 424 liquor license transfer? And if so, please just raise your hand. Okay, then that means I know why you're here. All right, well, thank you. I have no questions.
Commissioner Duffy, do you have any questions regarding the transfer? Commissioner Snoops?
I apologize. I do have a question for both the licensees. Do you have any financial interest in any other liquor store or alcohol beverage
No, sir.
in the state of Maryland? Nowhere?
No, sir.
Okay, very good. Well, you answered that question. No further questions, Mr. Praley.
All right, Mr. Chairman.
Okay, with that being said, this will be the quickest one tonight. I'm going to make a motion that we go ahead and accept the transfer. With that, I'm looking for a second.
I second the motion.
Thank you, Commissioner. All those in favor?
Aye.
Granted. Thank you. Good night. Sorry you had to wait so long.
Congratulations.
Not as long as these poor people in the back.
In connection with the last case of the evening, I'm going to read the summary, and then I'm going to ask for a head count of who is for and against this new license. This is for Summer House Pasadena, Coastal Ventures Pasadena LLC, Sudhakar Maneni, member, Shweta Bijan, member, Inspector Buddy Marshall. This is for a new license located at 9001 Fort Smallwood Road, Pasadena, Maryland, 21122. It's for Class D, beer, wine, and liquor, entertainment, which would be restricted to multiple TVs only, and Sunday license. So please, anybody who is for this, please stand. Everybody who is against this, please stand.
You get a count,
And we're
please.
getting a count. Sean's getting a count. Okay, folks, thank you. If you could have a seat.
9. Okay.
So,
All right, let the record reflect there are 9 individuals present in chambers who are here against the issuance of this license.
and folks, I'm sorry, if you could stand up, please, and raise your right hand. Do you solemnly swear and affirm under the penalty of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. And if you folks in the back could stand up, I'm going to swear you in. We'll see who's going to speak in a bit, but that way we're ready to hear whomever we need to hear. Please raise your right hands. Do you solemnly swear and affirm under the penalty of perjury that the testimony that you may about to give is the truth, the whole truth, and nothing but the truth? Thank you. You may be seated. Pardon?
The door is locked apparently.
Oh,
Yeah.
yeah.
Deputy Chief would go out and make sure it's unlocked.
I'm sorry.
No, that's fine. We're not supposed to lock you in anyway. Or out.
Inspector Marshall, if you could give your name and address for the record, please.
Buddy Marshall, Arundel County Liquor Board Inspector for the zone.
Thank you.
Good morning, good evening, Your Honor. My name is Pete Melkevich. I'm an attorney for Summer House. My address is 621 Gale Drive, Linthicum, Maryland, 21090.
Thank you.
Sudhakar Maneni, and my address 1605 Cambridge Road, Edgewater, Maryland 21037.
Thank you.
Hi, my name is Shweta Jain, and my address is 235 Braxton Way, Edgewater, Maryland.
Thank you. Oh, I'm sorry.
21037.
Thank you.
All right, thank you. Mr. Mikhaevich, we'll turn the floor over to you to present your client's case. You can do so by way of proffer, you can question your clients, or you can kind of do a hybrid combination of both, however
I
you
would
want
like to proceed, but
Sure.
And,
Go
and
ahead.
please let the record show that there are actually 12 people opposing.
There are a couple more people.
13.
Mr. Mikhaevich, before we get going, I want to
Okay.
swear those 3 individuals in also in case.
Yes,
they
the
testify.
individuals who just came in, could you please stand and raise your right hand? Thank you. Do you solemnly swear and affirm under the penalty of perjury that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth? Thank you. You may be seated.
All right, I'm sorry, counsel, go right ahead.
Thank you, Mr. President. As was previously stated by Mr. Ford, This is an application for a Class D beer, liquor, and wine license Sundays and entertainment for televisions only. I'd begin by proffering all the documents that have been submitted with the application. Also, we would also proffer the memo from planning and zoning showing this is an appropriate use of the property.
Those will all be admitted.
Thank you. The license applicants recognized that prior problems existed. There were 2 prior bars, apparently. One of them was Whitey's, Willie D's, and the other was Tucker's. And apparently Tucker's was a real problem. I ran into Mr. Bittinger in the hall, and he told me he represented Tucker's. And he and I talked about that briefly. And he said apparently there were problems with the owner. This owner is not that owner. This owner is committed to following the laws. He recognizes that the community has serious concerns. In fact, we reviewed some of the documents, and one of the pictures raised alarms for him right away. There was one picture that was proffered in the complaints that is this. I'm not sure. It's a picture for the road coming out this way, and there's a car parked right here. That's obviously an obstruction to people driving on that road. So that's very easy to solve. You just put cones there, prevent people from parking there to obstruct the view. There are solutions to all community concerns, and they're willing to sit down and speak to the community. We were unaware of any community concerns until we got here tonight. The White Cove community, we're willing to meet with them. We're willing to do whatever is necessary to help the community. John Gilmore is the commander of the Eastern District for Anne Arundel County. We're willing to meet with them. We're willing to talk to the Maryland State Police about setting up sobriety checkpoints to address the concerns of the community, to have drunk driving in the neighborhood. That's one of the big issues that I noticed. Now, not to minimize what the issue is for the community, but every neighborhood is adversely affected whenever there is a new business that opens, new traffic is created, new lines are created. Whenever there's a new housing development, neighborhoods are always opposed to new housing developments because it just increases traffic. And that raises quality of life issues. Going through all the complaints from the community, it appears that the biggest issue is quality of life issues, and that they're concerned with traffic, and they're concerned with people being drunk coming out of the bar. The bar has a capacity of 164 people. That's not a lot of people. And there's not going to be 164 cars. It's a new establishment. I can't see there being that many people going to the bar initially. We're willing to wear. I've gotten Mr. Marshall's card. One of the first things he's going to do if the board would grant the license is to have Mr. Marshall come out. He's going to call Mr. Marshall and ask him to possibly come out and go through. Thank you. Is there anything that you wanted to address, Mr. Mulani?
Sure. Well, we intend to listen to the community and address their concerns, and we intend to run the place in compliance with the liquor board rules. We take community compliance seriously.
Ms. Jane, do you have anything new to add from what Mr. Mulani had?
No, I think we are on the same page. Community does matter, so we will definitely like to work with them.
Thank you. Your Honor, I have nothing else. I don't want to hold the board up more than we have to.
Questions, Mr. Chairman?
I do have a few. When you considered purchasing or buying this or opening this establishment up, were you aware of the previous tenants?
Previous owners?
The people who were running the tavern, the bar, before you applied for?
No, I don't know them.
You didn't know them? No. Did you ever visit that establishment?
I did visit. I did meet them during the transaction, but I don't know the history.
I think what Mr. Harris is asking is, were you ever at the bar when it was previously opened as a bar?
At the bar, no.
And
Okay.
I don't know if that's what you meant.
That's where I was going, so thank you. You made that a little easier. Were you aware of the place when it was known as Tucker's? Did you know it, Tucker's? No?
No.
Okay, thank you. I think you're answering the questions that I had as far as previous knowledge. Were you, and I believe you also said, or your attorney said, that you were not aware that there was people in protest or against this being granted as a license. This board's very familiar with that building, that location, and that previous licensees. Question-wise, what are your plans with opening this establishment? Is it just going to be a bar, or do you want to do it? I mean, the license you're applying for is a D, which is a tavern license, beer, wine, and liquor. Do you have any other plans for it?
No, just a bar.
Just the bar? Yeah. Are you planning on having any kind of entertainment or music?
Limited, only limited to TVs.
I'm sorry?
Only limited to TVs, multiple TVs.
Oh, okay. I have no further questions at this time. Okay?
Commissioner Duffy, questions?
We spoke of crime in the area, and you also, your lawyer, attorney also spoke about the traffic. Are you aware of the traffic in the area? The parking and the traffic?
Yes.
May I ask you, so have you found a possible solution for parking?
Yes, there is I was discussing the same thing with my attorney, and there is a golf course close by, and I can talk to them to have our customers park at the golf.
Rent the parking spaces and
Yeah.
shuttle them.
It's just 0.7 miles away.
Yeah, that's
It's Compass Point.
familiar with it. You haven't talked to him yet, though, correct?
I have not.
I'm sorry, Commissioner, I didn't mean to step on you.
No problem. Thank you.
Yeah. The point that he's making, do you have something else you wanted to ask him?
No, I
about
was just relating to the traffic and the crime.
Well, the only crime I think raised in the complaints is there was a couple of protests that said there had been trespassing, and when people had parked out into the neighborhood. But as for parking on the street, that's an issue really for parking and zoning. It's not something for the bar. If parking is really an issue, the neighborhood should complain to the county and have them restrict the parking on the street.
Yeah, that wasn't meant for you. It was meant for somebody else. I'm sorry, Commissioner Snoops, do you have any questions?
That's the end of my questions.
Okay, thank you. I'm sorry.
Commissioner Stoops, do you have questions?
How many parking spaces are available directly at the bar?
I believe there are 12 spaces, marked
12
spaces, and then in the back there is plenty of space from one end to other end.
There's probably space, Your Honor, for about.
I believe, yeah.
There's probably space.
But
for
the bar
30.
holds 164 people.
Yes.
Yeah.
Got to have 4 or 5 people in every car. That'll be nice.
So I would say 25 to 30 cars, given the space in the back. Can,
If I may, I'm going to ask another question. Are you aware of the signage out on the road? Did you look at any of the signs that are on the road, either Fort Smallwood or Water Oak, I believe it is? Have you looked at any of those signs? Do you know what they say?
No, I'm not aware of that.
Okay. There are, if I remember correctly, and I've been out there, not for this particular case, but the previous licensee, I believe we have 5 no parking signs on both sides of Water Oak Point Road, both sides. So from your establishment going into the community, there is no parking along the road. And if you didn't recognize those signs were there, then maybe you're under the impression they could park there. Well, trust me. Anne Arundel County has been out there, and I have seen where they have towed many cars, and then the customers or patrons of the place come out of the establishment to find they don't have a car because it's been impounded. Hopefully somebody should have made you aware of that. It's been a real problem. Go ahead.
Would you be willing to put a sign up inside the bar that says, please note you're not allowed to park on Fort Smallwood Road?
Sure, I would do that.
What kind of security do you plan on having, if any at all?
Yeah, I plan to hire security people.
Staff, security guard, officer, whatever you want to call them?
Yes.
Bonded and licensed, right?
Yes.
I have no further questions at this time.
Okay. If the commissioners do not have questions, I think right now we can hear from members of the public, and then we'll give council an opportunity to reply. No questioning of the members of public. It's just going to be public comment, but you will absolutely have the opportunity to reply to any comments. So hold on one second. All right, I just conferred with the chair, and we're going to ask for one representative of the community to come up first. And the way this is going to work is we're going to allot 2 minutes each. I see a volunteer in the back. We're going to allot 2 minutes each to an individual who wants to testify. However, it is getting a bit late, and we don't, and I apologize, I appreciate everybody for hanging in there, but we don't want to repeat comments on the same issues. So after the representative speaks for 2 minutes, if you have something that has not already been said that you would like to add, please feel free to come up and you can be heard next. So when you come on up, state your name and address for the record. Everybody in here has already been sworn, and then we will time you. I believe we have a timer. Hopefully it's working this time. We never know. But we also have, it's working? Fantastic. Oh, it's a new one, fresh out of the box. So we'll give you 2 minutes to testify, and let us know when you're ready. Yep, just name and address for the record first, and then we'll let you know when we're ready.
Okay, my name's April Grimm, and I'm at 7907 Oak Point Court.
Okay, ready? Here we go.
Okay. So the main thing that everybody has an issue with is parking. My yard backs up to Water Oak Point Road. I have a driveway in my backyard where my camper is. There's cars there all the time. Parked in the yard, parked on the street. The parking that is on the street, you have everybody with their music and they're fighting and they're yelling and the trash is getting thrown in people's yards. They're parking in the neighborhood, cutting through other people's yards, all the things. When Tucker's was first started going, a group of the neighbors walked over to speak to Mr. Tucker to explain to him our issues with the parking. We don't want people in our yards. We don't want trespassing, all this stuff. And, he was going to be our best friend and take care of everything. That didn't happen. I'm sure you all know about him. And then again, when the bar was taken over by the 2 gentlemen who said they were running Summer House, again, my husband and I went over and said we had all these issues with Tucker's, the parking, the trespassing, da-da-da-da. They were going to be our best friends as well. That did not happen. Nobody monitors the parking. They said they were going to put signs up. They did not. Every weekend, we were calling constantly. It's disrupting the entrance to the community. None of that ever happened. It's not just issues with the owner. It was issues with the establishment. It can't support it. There is no parking for a bar. All the, noise, everything else, it's not there for the community. The community does not want it nobody's monitoring the parking. You say you're going to, you're not. And I don't think that you guys live in Pasadena, so I don't think that you understand how big of an issue this was for our community, and it's not something that we want. You know, I have pictures on my phone of my entire yard and house being lit up like the 4th of July from police because of parking and fighting. And, you know, I saw a cop car get hit by another car while he was trying to move cars off of the street. It doesn't work. It's never gonna work. Oh, and I'm sorry. You can't put cones up. You guys, somebody put caution tape up along the entire side of the road. So you drive back into a community with $800,000 houses and you have caution tape. Thank you.
Thank you.
Thank you.
Does anybody else have anything they would like to add to the public comment? Yes, sir.
Yes, please. And please state your name when you get up and have a seat, and just let us know who you are and your address.
Christopher Grimm, 7907 Oak Point Court.
All right, Mr. Grimm.
She had touched on the parking, but they had also said they were going to do a shuttle, and the shuttle created just as much of a nuisance as the cars did, because the shuttle would sit out there with the radio blaring all night, taking people here and there and moving them around. And then there's the bathrooms. They don't get adequate bathrooms, so we see men and women roaming through our backyards, urinating and doing, maybe puking also, just coming and going. And then just the general noise from the club itself, it's right there. They keep the doors open because it's so small and it gets real hot in there. But the bathrooms and the noise are the worst. And there's just people roaming through our yards, puking and peeing all night. And the cops try to contain it, but there's only so much they can do with the resources they have. And that's all I got to say about it.
All right.
Thank you.
Thank you.
Ma'am? All right, just name and address and we'll give you.
My name is Wendy Kohler, and my address is 1459 Old Fort Smallwood Road. I am directly across the street from them, directly. The only thing separating us, besides the road, is my woods, the trees. I've lived next to this bar for 35 years. I've put up with a lot of it. And everything that's said, it's not going to change. we don't believe that this establishment, this location, is fit to be a bar. It's another quiet organization, but 164 people, I've been in that bar. If you put 164 people in there, the parking's not going to fit. And nothing was said that I knew of about the accidents coming out of Water Road Point onto Fort Smallwood Road. I was hoping to be able to get the statistics for tonight, and I take care of my husband and I just haven't had time. But there have been so many serious accidents right there from that bar. And statistically, if anybody can look up and see how much the accidents have stopped since the bar's been shut. And I believe that it's being leased instead of sold, and if it would have been sold, we could have rezoned it for residential. That's all. Thank you for listening. Please help us keep our neighborhood peaceful and quiet. Thank you.
Anybody have anything else they'd like to add? Yep.
Hi, I'm Julia Smith, and I live in Stony Beach. My daughter lives on Oak Point Court. And one night, I was babysitting, and there was a lot of commotion on Water Oak Point Road, and all of a sudden, a truck came from the back of their house straight up through their lawn, drove straight up to the front of their house, and this is not a road, this is their lawn. And I got scared. I was babysitting and called and said somebody just drove from the back to the front, and big tire marks left in their lawn, and we never found out who it was, obviously, but then there was a lot of commotion in the back there. People were fighting and yelling obscenities at each other on the street. So that's all I have to say.
Thank you.
Anybody else? Okay.
Good evening, Michael Farley. I live at 1312 Water Oak Drive, Pasadena, Maryland, 21122. And in addition to the parking, I think one of the issues I have personally is trying to get into and out of the neighborhood. My wife, she works evenings. So when that bar is occupied in the evenings, you cannot see the traffic coming westbound on Fort Smallwood Road because of the cars that are parked so close to that travel lane. The speed limit is 40 miles an hour. 40 miles an hour, you're driving about 60 feet per second. So you have how many seconds to pull out of Water Oak Point Drive to get onto Fort Smallwood Road? So I think it's, in addition to the parking issue, it's that getting in and out of the neighborhood, as some of the other folks have said. And for the interest of brevity, this is an accident report from my daughter's car was hit by 2 drunk drivers. And I don't know if there's a way to enter this into the folders or anything, or the documentation, but I'm also curious, there's a March 30, 2023 letter that I sent to the commission.
I would object to any document.
Yeah, we're not going to, this is just testimony. We're not going to
Well, in that
enter
case,
anything.
there's a very scathing letter against having that established open up. But again, there's an accident report from 12:01 on January 8, 2022. 3 motor vehicles involved, 2 of them were drunk drivers that were arrested by the Anne Arundel County Police. I think that speaks volumes to the safety issues regarding operating that establishment as a bar or restaurant. So that's it. I give my 25 seconds to the next person. Thank you.
Thank you.
Anybody else? Okay. Before everybody leaves, make sure to please sign the sign-in sheet, just so we have an accurate record of everybody who was here. I understand some people may have left, but as of right now, there's only 5 people who are signed on here, including the 2 licensees and the attorney. So make sure that you just sign this, just so we have an accurate record. Thank you.
Yeah, and that is very important that you do sign that, so please.
Mr. Malkovich, if you want to...
Yes, thank you.
Sure.
Sure.
Oh, hold on. I apologize. Jump the gun here. I believe that the chairman wants to hear from Inspector Marshall, who's assigned to the establishment. So, Mr. Marshall, were you sworn in?
Yes.
Okay, great.
Yes, he was. Inspector Marshall, just a couple questions.
Inspector Marshall, your microphone is off. I apologize, Mr. Chairman.
It's fine.
There you go.
And you can see how many times you testify.
Yeah.
All right. Inspector Marshall, as you mentioned, is the inspector for that particular sector or area. And he's very, very familiar with not just the physical locale, but the previous establishments. And I'm not just talking about Summer House or Tucker's, but even Willie D's. Yeah, I know. So what I'm going to ask him, the questions I'm going to ask him is really, it's a matter of making public some of his knowledge, but also to make you aware of what has occurred there. And before I do, I just want to make you aware that this board is very familiar with those previous licensees and the police reports and incidents. We have CAD printouts and so forth. But Inspector Marshall, how many years have you been an inspector?
I'm not sure.
Just earlier, we referenced that somewhere 18 to 20.
Okay, that's good enough. And you've worked that Pasadena area?
For at least the last 10, maybe 12 years.
Okay, very good. So, and you're familiar with the intersection we're talking about, Water Oak Point Road and Fort Smallwood?
Absolutely.
You're familiar with 3 bars or taverns that I mentioned, Summer House, Tucker's, and Willie D's?
Yes, sir.
Okay. How many times have you been out there and observed, well, let's start with parking violations or parking and traffic. And what's your opinion of the reasoning behind the problems with the parking and the traffic?
I guess the best way to describe the parking situation is opening night for Summer House. There was so many cars trying to squeeze on that lot, there was an accident on the lot, which I believe you were with me at the time. So, but basically, the parking situation is atrocious. I mean, I would dare to say over 25 cars, and you're going to have to crawl out the sunroof because doors aren't going to open.
Okay, thank you. You've been out there and spoke to some of the licensees in reference to complaints from the neighborhood. And just what were the subject lines of those complaints?
The subject line basically, and there was numerous times I've been there on complaints, and basically it was the outside environment of the establishment. It was so crowded on the inside that they just ended up out on the parking lot. Motorcycle clubs were hanging out there and just carrying on like a bunch of lunatics. And every time I went there and warned them about things that were happening, and of course they always said that they would be corrected, I could go back the next night, which I did numerous times, and the same type of situation was ongoing. There was just no reasoning with.
Okay, I'm not just looking for negativity or things of that nature. I'd also want your opinion as to what you may feel would be a benefit of allowing a tavern to reopen at that location, if any.
Each one of these folks that went in after Willie D's promised the same thing. It was just going to be a neighborhood establishment. They were going to work with everyone. And of course, it didn't take them long to go downhill. These folks here may do just that. I mean, just operate a local tavern and hopefully abide by all the rules and regulations and try to keep everybody happy in the neighborhood. There's no guarantees. I can only take them at their word.
Okay.
The benefits for the area, I don't know as there are any. There's plenty of liquor establishments close enough by that it really doesn't need another licensed establishment. But of course, that's up to the board.
Okay, thank you. I have no further questions for the inspector.
Mr. Duffy, do you have questions?
No.
Mr. Stoops? No questions. All right.
One last thing I might interject, if that's okay. The establishment did have one of the largest turnout of police response on record, I do believe, on one particular night. Now, that's no reflection on these folks who are coming in. But
No, I remember that night, and you're right, it is no reflection on
Right, I just
the
wanted to
applicants.
establish
They had every single police unit in the Eastern District there one night. Every unit, not most of them, every unit that was available in the Eastern District. But anyway, thank you very much, Inspector.
Yes, sir.
Council, do you have questions?
No, thank you.
Thank you.
Yeah, so we were unaware of the severity of the problem with the prior owners. My client is committed to, and I know they've heard that before, and that's, Your Honor, I was wondering, perhaps if there becomes a problem, we would be more than willing to enter a memorandum of understanding with the community, where we put in writing what we're going to do, and if we don't, that puts the license immediately in jeopardy. That is something we're always willing to work with the community. we understand how important it is to be a good neighbor. It's the parking issue. I was not aware that that was so severe. Especially the signs on the side of the road. I had no idea. But that's why the shuttle service that one of the witnesses, I believe it was Mr. Grimm, said, forgive me if I'm wrong, Mr. Grimm, said that they were blaring music. Well, that's easily settled. You just get a different shuttle operator or you turn down the radio. I think the biggest issue for us is that zoning says this is okay. And it's zoned as a commercial area. The area is zoned properly. It's legal. I think they deserve a chance, Your Honor. Other than the anecdotal experiences they've had, I don't see a legal reason to prevent the new owner from taking over. And you can even condition that on establishing a memorandum of understanding if the board feels that's necessary. Thank you, Your Honor. I'll submit it later.
Okay, thank you. Gentlemen, I have two people in the back, but we gave them an opportunity.
The time's already come and gone, guys. Sorry.
I'm sorry about that. We recognize you, but that's about all we can do. Okay, in a different manner, what I just spoke to our attorney about is, I think in this case, we're going to ask for a written opinion be sent down. That means our attorney will talk to the commissioners, and then whatever that decision is at that time will be forwarded to you and your clients. And also the public will be made aware of it. There's a lot to consider, and I think the importance is, we have how many 12 people sitting in the back at 11 o'clock at night or 10 something at night who feel pretty strong, but at the same time we have somebody who I think was unaware of the previous situations, and unfortunately, that may not help them out. But anyway, what we're going to do is I'm going to go ahead and make that a motion that we hand down a written opinion, and we'll see that it's done in expeditious manner as we can.
Right, and in all likelihood, the board will put a decision on the record as soon as we're able to, and the written opinion will be issued contemporaneously with that. We'll just have to put it to a vote first.
Thank you, Your Honor.
Okay, thank you. Good night. Good night. You want me to do what with this? All right, the hearing is over. Thank you, everybody.